For reasons mentioned in the order, the prayer for bail of the petitioner is rejected. Yes, any mention?
May please your lordships, item number 13. This honorable court lordship, pass off for day lordship. 13 lordship. Bail hearing.
13 of this court.
This court lordship.
Steno court.
Lordship, here charge sheet has been submitted.
Steno.
Session is 11. Session is enough.
Item number 13 of this court. On request of
Lordship,
And
charge sheet has been submitted.
charge sheet has been submitted.
Yes, Lordship.
Then what is to be done? We'll take it up on
He can approach the
in the month.
trial court,
he can approach the court below, Lordship.
What was the matter?
Commercial quantity, Lordship. 21C.
You approached the court.
lordship.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
09/2024, dated 5/8/2024.
in view of the laying of the charge sheet. This bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for bail before the said court if so advised.
Diploma. May please lordship. I beg to mention item number 43 lordship of court number 14 lordship.
Yes,
In this matter, lordship, my senior ASO will appear, lordship. Today he is not well, lordship. Letter may come up on Tuesday, lordship.
CD is with us, Lordship.
okay, heard Mr.
Yes, Ali, lordship.
S. Ali, who prays for an adjournment on the ground of difficulty of learned conducting counsel, Mr. A. Sakya. The prayer is allowed. Let this matter be listed again on
Tuesday.
Tuesday is which date?
13,
13th August. The case diary which is available shall be retained till next day.
published.
May I please, your lordship. Regarding item 14, lordship, let it come on next week, lordship, on 6 of this court,
Item number 14 of this court.
lordship. Transition matter, lordship.
Heard Mr. S. Munir, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed again in the next week. Which date?
16, lordship, 16 or 19, any day.
16th of August 2020.
Much obliged. Much obliged.
May I please, your lordship, in respect of item number 14, or item 14, item 20 of all 14, the matter may be taken up next Tuesday or Wednesday. The arguing counsel, Mr. D. Das, is having some personal difficulties today. Lordship.
Heard Miss, what is your name?
Tin Lung,
Tinlung, learned counsel for the petitioner,
20.
who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed on.
Tuesday,
What is the date?
13/8.
13/8/2024.
Deeply obliged.
May it please your lordship. I beg to mention item number 6 of court number 14, my lord. Lordship, this matter may kindly be taken up on 14th, my lord, 14th of August, my lord. Item 6, of court number 14.
Heard Miss B. Bora, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed on 14/8/2020.
I'm deeply obliged.
May it please your lordship. As regard to for item number 35 of court number 14, there is a VC request, and as per the cause list of court number 14, it was to be taken up as the first item. Can it be taken up as the first item in this code as well, Your Lord?
First item, okay.
Highly obliged.
With regard to item number 55 of court number 14,
Item number,
55. Court 14.
yes.
On 6th of August, my lord, the matter came up, my lord. On that day, my lord, Amicus was appointed in the case, my lord. And it was directed that the name of the Amicus be reflected in the cause list. But today, the name of the Amicus has not been reflected. So, my lord, let the name of the Amicus be reflected in the cause list, and matter may come up on some other date, my lord.
Heard Mr. K. Mani, learned counsel for the appellant, who submits that by order dated 6/8/2024, registry was directed to reflect the name of the learned
Amicus.
amicus who has been appointed in this case. However, today the cause list has not reflected the name of the learned amicus curiae. Hence, let this matter be listed after a week on a date to be fixed by registry.
Let it be on 14th, my lord, yes. On 14th of August.
Let this matter be listed on 14th after reflecting the name of the learned amicus curiae in the cause list.
The name of the amicus query is
That is
Debashish Kumar Bhattacharya.
Mr. Debashish Kumar Bhattacharya.
I'm deeply obliged.
May it please your lordship, I beg to mention item number 7 of court number 14. My lord, some instructions are awaited. So my lord, may kindly take up the matter on 12th.
Heard Ms. K. Sharma, learned counsel for the petitioner, who prays for an adjournment on the ground that some instructions are required from the petitioner. The prayer is allowed. Let this matter be listed again on 12th of August 2008.
May I please to resolve, Lordship, item number 26, court number 14. We are not able to contact who is a petitioner.
So what is your prayer?
Lordship, kindly this matter fix 19 and 20.
My lord, I am for the sole respondent, maybe on 16, my lord, because
16.
they,
16.
Some stays there.
stay is there, that's why, my lord.
Okay. Heard Mr. What is your name?
Jai Islam.
J. Islam, learned counsel for the petitioner. Also heard Mr. M. Saranya, learned counsel for the respondent. On request of learned counsel for both the side, let this matter be listed again on 16th of August 2020.
I love.
Regarding items number 29 and 30 of court number 14, my lord, with the consent of the other side, my lord, we're praying for adjournment, my lord. Matter may come up after 2 weeks, my lord. There's some developments going on.
Heard Mr. S. Nawaz, you have informed.
Inform, my lord, taken consent, my lord. We're
Heard
present.
Mr. S. Nawaz, learned counsel for the respondent.
Petitioner, my lord.
Learned
In item
coun-
number, we are the petitioner in item number, the transfer petition in item number 29. IA has been filed by them.
learned counsel for the petitioner, who prays for an adjournment on the ground that some
Developments
instructions
have been going on between the.
are required. Also heard Ms. F. Hussain, learned counsel for the respondent, who does not opposes the prayer. In view of the submissions made by learned counsel, let this matter be listed after 2 weeks on a date to be fixed by registry.
There are interim orders in both transfer petitions.
The interim order shall continue till next year.
May I please say, lordship, daily item 24, double two, lordship, court number 14, lordship. 22.
20,
22.
22.
Yes, lordship.
Yes, what is your prayer?
No, lordship, pass over the matter, lordship.
Adjournment. Heard Mr. What is your name?
A. Rahman, lordship.
Heard Mr. A. Rahman, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed again on 20th of August 2024.
Can it be 16, lordship?
Okay, 16th August.
Obliged, lordship.
May I please, lordship? I beg to mention every filing serial number
7015/2024 for posting on Monday.
Mentioning before some other court, there is a notice. Senior court. There are other courts taking and anticipatory bail matters. You mentioned before the senior court.
Item 45 from court number 14.
May lordship, please. May lordship, please.
Yes, yes.
Yes, lordship. My lordship is at FIR at page 23, my lord.
Is it a charge sheeted case?
No, lordship. Absolutely, what happened in my lord? In 2021, the FIR was logged.
Mr. Botha, whether
Case diary
case diary is there?
My lord, I will have to go through in some detail, my lord. Because voluminous case diary, my lord.
Yes.
On the last occasion also, the same thing has been happened, my lord. So
No,
there is a difficulty.
Let him go through. We will take it up today itself. In the second
Lord-
half, let him go through the case diary.
Lordship, case diary, my petition is very bulky, my lord. In the earlier day, the case diary is very, 3-4 pages per it. My petition is page about 400 above, my lord. Because I have enclosed a 74 pages of inquiry report. That may explain, your lordship, nothing remained there. Absolutely what happened, the inquiry was conducted, the departmental inquiry, and the final report was submitted. The main person against whom the charges has been leveled, he is the registrar of the university. He was allowed on anticipatory bail. Or in otherwise, Monday maybe matter been fixed, my lord.
Monday.
Monday, my lord.
Okay.
But
we are-
I only request, my lord, that the additional PP may go through the same additional PP may be there in the roster. In whoever the court may be, my lord, there is nothing.
At 2, I can, my lord.
No, let it be on Monday.
Monday.
Today, 2 courts matters are there.
Yes, that's one.
Heard Mr. B. Dr. Learned Senior Counsel assisted by Mr.
J. Das.
J. Das, Learned Counsel for the petitioner. Also heard Mr. P. Upadhyay. P.
Bhattakur.
Sorry, P. Bhattakur, Learned Additional Public Prosecutor, who submits that considering the fact that the petitioner is very bulky, he needs some time to go through it. The prayer is allowed. Let this case be listed again on 12th of August 2024.
My lord, grateful, Lord.
Court number 14, item number 1.
CD administrator, lordship 390.
Heard Mr. S. Munir. Also heard Mr. B. Sharma. Call for the case diary. Fixing
21-8.
21-8 for case diary.
Much obliged. Much obliged.
Item 2.
Wait, please, your lordship. Case registered under section 103 earlier 302. CD may be called for, my lord.
Heard Mr. T.J. Mohanto, Learned Senior Counsel assisted by Mr. R. Sharma, Learned Counsel for the petitioner. Also heard Mr. B. Sharma. Let the case diary be called for.
21-8.
Fixing 21-8 for case diary.
Deep Lord.
Item 3.
May I please, your lordship, kindly let the matter be taken after some time, lordship. The
We-
Bora will appear, lordship, he's on legs, He'll come and appear, lordship. Let it come after.
What is, whether case diary would be required or not?
Would be required, lordship.
Lordship, let him appear, lordship. Instruction, he will be appearing, lordship.
No, we will call for the case diary.
So actually, the,
You hope that without calling for case diary, you will get relief in this case.
lordship,
Is there any hope?
lordship, there is hope.
Okay, we'll take it up after some.
51 and 52 also similar matter.
Along with this,
Yes.
okay. last item as in the motion.
May it please. Offense of 376.
Three-
Surrender before the court he is in custody since the last 50 days. Your Lordship. So the case of false promise to marry. Our contention
Puttur.
is that Your Lordship,
PNSS
376.
376.
Yes.
We'll call for the case diary.
Along with this statement.
Heard Mr. G.Z. Ahmed, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. Call for the case diary fixing
Lordship 16-8.
16-8 for the case diary.
Lordship, can it be on 20, Lordship? I'm sorry.
28 for case diary.
much of it.
Item 51 supplementary is code number 40.
But
50.
50,
50.
50. Oh, 50 my case. In this case,
what is 309?
Miller.
What is the offense?
Offense 3094 Miller.
What is the offense? It is this.
Robbery Miller.
We are calling for the case diary.
Robbery Miller in this case, petitioner not named in the affair Miller.
But you are behind the bars.
Miller, there is the allegation Miller.
Heard Mr. A. M. Ahmed, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the case diary fixing
21-8.
21-8 for case diary.
Item number 53 from code number 14.
Last Matla.
Item number 5, code number 14.
Please, Lordship, here is a case, my lord, on same set of facts. My lord, two cases has been instituted. One is land grabbing case, on another is, my lord, complaint case. Now, my lord, so far the land grabbing case, Lordship, is very well that is a special legislation covering the both civil and criminal nature. Now, despite of that, my lord, the existence of the ordinance taken care of in regard to the complaint is not maintainable. Lordship, state where I am coming, page 29.
Yes.
My lord, here is a case which has been filed under inviting section 82 of the Assam Land Grabbing Act 2010, read with Rule 2013. Now, Lordship, the operative part of the contention, which contained in page, my lord, 4040, paragraph 20. This is the core issue of incident, my lord. Paragraph 20. Page 40.
Now cognizance has been taken.
Yes, my lord. My lord, my submission is that, my lord, it creates a conflict of decision, my lord, because on same set of fact, two decisions cannot be run together, my lord. And my lord, once the higher authority has already looked into the matter under inviting special legislation, my lord. My lord, the complaint case deserve no any value in the eyes of law, my lord. Lordship, kindly see only one paragraph I am reading, paragraph 20, page 40. That
Yes.
on 25/2024 at about 10 AM, the respondent had coming into the respective bikes and car illegally enter into the suit property by forming unlawful assembly and demanded the Manager Sri Bachchan Chauhan to call the owners of the brick field. However, due to the unavailability of the Durmudma, the owner could not be able to visit the place. The said person left the brick field with a demand to the manager and worker not to carry out any work. And thereafter 26/2/2024, they called news channel, etc. These are the incidents. Now, Lordship, kindly look for a moment the CR case that contained in page 20, my lord, 25.
Otherwise, is there any other bar in taking
Absolutely,
cognizance?
my lord. Section 9 clearly says, my lord, kindly read for a moment, my lord. Page 9.
Page?
I am quoting. My lord, page 14, section 9. of the Land Grabbing Act,
Page
14.
14.
There is an embargo, my lord. Section 9, special tribunal to have the power to civil court and court of session, my lord. And lordship, well known that reference case number 1/2027 passed by this honorable court, where it is clearly indicated that the special tribunal first decide the criminal side. If that would be proved, then therefore go for the civil side, my lord. Therefore, the dual purpose would be served in land grabbing case, my lord. Now, having this position, my lord, a similar criminal case is not maintainable, my lord. At this moment, my lord, I pray that lordship may issue notice, and so far the CR case is concerned, my lord, our appearance is next week, my lord. That may be stayed, my lord, till later noted.
No, what is the judgment, what it says?
My lord,
The
reference
judgment-
case number 1/2000 basically dealt with the issue that once a FIR has been lodged before the police station. Now, if they authorized to take care of that land grabbing issue or not, my lord, then reference case number said not, once even FIR has been lodged, it has to refer to the case to the special tribunal. Therefore, it indicates
Where is that observation?
my lord, reference case number 1/2027, my lord, right now I don't have, but lordship, if lordship require, I will place it, my lord.
I require it.
My lord.
You will take it up after some time.
My lord.
You bring that.
My lord.
Yes,
May I please, your lordship? Item number
yes, what is this?
For issuance of warrant, my lordship.
Yes, make your submissions
Lordship, charge sheet has been submitted, my lordship.
thereafter.
Thereafter, warrant is summons has been issued, my lordship. I didn't receive any summons, my lordship. Thereafter, warrant has been issued.
The sheet submitted under what provision?
My lordship, section 21, 22 of NDPS, small amount, my lordship, 5 gram. So maximum punishment is
21 A.
21 and 22 NDPS. Maximum
where-
punishment is 1 year,
Where is the charge sheet?
my lordship.
This is the type copy, lordship.
Type copy, my lordship, and only 5 grams in total, my lordship. So it's a small quantity. 1 year is the maximum punishment and 10,000 fine, my lordship. The charge sheet I have been shown as absconder, my lordship, but real fact is that I'm not absconding, my lordship.
5 gram is small
So
quantity.
uncontrollable.
Yes. Continue.
Less than 5 gram is.
Yes, lordship. Yeah, lordship, the only thing is, lordship, the FIR is of 2016.
No, whether 5 gram is small quantity or not.
Um,
Um,
5 grams.
5 gram in total, small
Small
quantity.
lordship.
5 gram is not small quantity, perhaps.
Up to 5, lordship.
Up to that.
Not up to. It is less than. What is the definition of? Small quantity in relation to narcotic drugs is lesser than the quantity specified.
5.
Lesser than, that means
Lesser.
it has to be less than 5
Less than
grams.
5.
So 5 grams is intermediate. quantity.
Intermediate.
It is exact. Okay, no, that is not the matter here.
Yes, lordship.
You received the summons.
No, my lord, I didn't receive it. There's nothing
Thereafter?
there. After my lordship, warrant has been issued, my lordship, I came to know about the charge sheet, my lord.
Which
Even when the search and seizure was conducted, my lordship, I was not present, my lordship. It was in my shop, medical shop, my lordship. I went to my home for taking lunch. At that time, officials of the excise department came.
by which order this Warrant.
15 Lordship.
Page 15.
You have not annexed the earlier orders.
Yes.
So how will we know what was your conduct?
More or less, Lordship, the FIR is of 2016, Lordship.
At least you have to be fair to the court. You have to annex previous orders also.
I may be allowed, I don't have that copy, I may be allowed to submit those.
Okay, submit it.
Yeah.
When?
In 1 week, I'll submit.
Okay. On the request of heard Mr. S.B. Locker, learned counsel for the petitioner, who prays for some more time to bring certain documents on record by filing an additional affidavit. The prayer is allowed. Let this matter be listed again. When do you want it?
A short date, my lordship.
Suggested date
Yes, Lord.
on 16th August.
Oh, okay, ma'am.
16th August.
Highly obliged.
My lord, here is a case, my lord, the quashing of the complaint has been solved. The lordship will kindly see, a complaint petition was filed on 16/6/2022 on the ground that a check was issued for payment. The check got deposited in the account, but it was dishonored on 20th of September 2021. Now, thereafter, the notices were not sent till the time 30th of April 2022. Now, as per the requirement of section 138, the notices were required to be sent within a period of 30 days. But the complainant did not send the notice, and therefore, my lord, as on the date of filing of the complaint petition, the statutory requirement was not fulfilled. Now, after filing of the complaint petition, my lord, the complainant remained just like that without taking any appropriate measure. Suddenly, my lord, on
When complaint was filed?
complaint was filed on 16/6/2022. And on that day, my lord, the so to say, the cause under 138 of the Act, my lord, that did not survive because of the failure of the complainant to serve notice in time.
Within
30 days.
30 days, as per
138. Now, thereafter, what the complainant has done, after 16/6/2022 matter remained like that, on 30th of August 2023, complainant filed an application seeking condonation of delay on the ground that the Honorable Supreme Court had passed the orders exempting the period during the corona time. Now, that 30th of August 2023 application was immediately taken up by the learned court below, and on the same day, without issuing any notice to me, the delay has been confirmed and cognizance has been taken. Now, in my respectful submission, my lord, the order of the Honorable Court, learned court below, seeks to inject life into a deadless, lifeless body, because on the date of filing of the complaint petition, my lord, there was no cause. If the complainant had to take the benefit of the order of the Honorable Supreme Court, my lord, then it was required to be premised on that ground. Nothing in the complaint petition has been stated that on this ground I seek a waiver of the time limit. Now, without recording any reasons in support thereof, or without giving any notice to the accused in the case, my lord, the impugn order is passed. That is at page 41.
Page
41. The lordship will find the petition that was filed at page 23. Your lordship will find the petition. The CR case. In CR case 4118 of 2022.
page 23.
23. Now, in this petition, my lord, they seek a condonation of 192 days in serving the notice. This petition was numbered as 3108, and it was taken up on 30th of August 2023. Your lordship will
But
kindly,
before that, cognizance was taken.
on the strength till that date, my lord, no cognizance was taken,
Okay.
because it could not have been otherwise taken because of the bar in the provision. Since the
So after condoning the delay,
after condoning the delay, my lord, the
cognizance
cognizance has been taken, and this condonation has been done without any notice to me. Otherwise, also, my lord, by passing this order, my lord, at page 41, my lord, your lordship will kindly see the petition which could not, of which, my lord, cognizance could not have been taken earlier. And that view of the matter, my lord, the petition was on something like non-existing in the eyes of law, my lord. In that petition, my lord, the order has been passed and cognizance has been taken. The basic grounds for taking cognizance is that, my lord, there has to be a triable cause. And on the day of filing of the complaint petition, my lord, that is on 16th of June 2022, my lord, the basic requirements were not even fulfilled. And the complainant also did not sought any condonation or any waiver of time as on the date of filing of the complaint petition.
Therefore,
Therefore, my lord, till the time this petition was filed, that is on 30th of August 2023, my lord, it cannot be presumed to it cannot be considered to be a live petition pending before the court. Because as on date of 16th of June, my lord, the petition was already barred by
so
time.
your submission is that on 16th of June 2022,
Yes.
on that day itself, there should have been a prayer for
Yeah,
continuity.
exactly. On that day itself, there should have been a prayer, and if the prayer was also to be considered on that day, at least
Notice
a
also
notice was, was to be given to me.
heard Mr. S. Dr. Lanet, Senior Counsel, assisted by Mr.
P. Sen
P.
Gupta.
P. Sen Gupta, Lanet Counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, now will it be filed under 482?
Well, the proceedings have been drawn under the old code, my lord. I mean, before coming of the BNS.
But the quashing petition is you are filing now.
But
So the petition is not pending. So whether in
that case, my lord, only the number, there will be a typographical correction in the cost title that it
yes,
should
you
be under
correct that.
528. But my submission, my understanding is that, my lord, since the proceedings had already commenced prior to coming of the BNS, my lord, that's why, my lord, it will be governed by the old act, because the BNS is also prospective in nature.
No, on that some light has to be. I need some enlightenment because the 531 section 531 says pending applications for. You read 531 now.
Now, my lord, here cognizance has been taken prior to coming
No,
of the.
we are concerned with the application which is before us.
Whether the current petition.
Current petition. We are under what provision the current petition has to be filed? Under the new provision or the old provision?
In that case, my lord, it will be 528.
Yes.
528 of the.
Perhaps.
Yes.
You make corrections.
Yes. That will be.
Then I will not pass orders today. First you make corrections.
Your lordship can take it up at the end of the day, list, my lord. We'll make the corrections.
In the meanwhile, you may make corrections.
Yes. If your lordship permits, it can be, the provision can be corrected by hand, or we'll give a typed copy of this also, this page.
Or let us fix it tomorrow.
Tomorrow, in that case, it will go to 12th. my lord.
12th. If you look into this issue, if correction is required, you have to make correct. Because for making corrections also, there is a notification.
That's why I said, my lord, in that case, we'll have to replace the page with a typed page one.
Yes.
Typed one page. That we can do, my lord, in the course of the day, my lord. Your lordship can take it up at the end of the board.
Okay.
Huh?
Then we'll take it up. You may make
Yes,
necessary
yes.
corrections. Last one. Correct.
Kindly, lordship. The application is filed under against the order dated in order 9/7 passed by the land special days of Garvey and Block.
No, you have to be louder.
The application is filed against the order passed by the Lanet Session Judge, Special Judge, NDPS, Garvey and Block on
Oh.
this order was passed on 9/7/2024, Lordship. Kindly peruse the,
Where is the impugned order?
yes, Lordship. Page number 14, Lordship. Annex 1. And 15 is the order.
This order you are impugning.
Yes.
What is your grievance?
Actually, what I mean, Lordship.
Summons are issued.
Lordship, what I mean, Lordship, on, kindly peruse the Lordship, page number 13, Lordship. Here is the order, Lordship. On 25/6/2024, Lordship. The accused, Zarabir Gurung and Sagar Dunga are produced from the jail, remain in PW has been examined. Cross-examined and discharged and issued summon to the seizure witness of scientific research. Again, and next date is fixed for evidence on 24/7. On 26, Lordship, kindly peruse the Lordship 43. Page number 16, Lordship. Page number 16, Lordship.
Yes.
Lordship, kindly peruse the Lordship order dated on 26/6/2024. CR put up today a petition via petition number 91/2000 has been filed by the additional public prosecutor with a prayer to re-examine the PW SI Deepak Lahon. He was already examined, Lordship, on 25th.
Yes, therefore prayer for re-examination.
Yes. Yes, Lordship. Again, he is filed an application, Lordship. Again, filed an application accordingly on 9/7/2024, Lordship. Order has been, the petition has been allowed and fixed and date, on date, yes, Lordship, on 27/2024. Initially, 25, it was fixed on 7/2024. But on 9/7/2024, it was passed an order and evidence was fixed on 27/7/2024.
Yes.
Lordship, kindly peruse the page number 44. This is the petition, Lordship.
No, what is your grievance?
Even Lordship, without hearing me, Lordship.
Or without
We-
hearing you,
Yes,
that
Lordship, the
re-examination
petition is
prayer was allowed.
Yes, Lordship.
Okay.
On 24, we have appeared, Lordship. On
Now
the
whether
day
he has been
parties are-
examined, re-examined,
Yes, Lord.
he has already been
He-
re-examined.
No, already he has been examined,
And
cross-examined
then-
and discharged, Lordship.
And again re-examined also.
Yes, Lordship.
No, re-examined to one.
No, re-examined not.
It has been allowed, Lordship.
Allowed, Lordship.
Okay. When is the date fixed?
It was fixed on next date, I think, Lordship, next date was fixed on.
They have mentioned it somewhere, Lordship. I think. Lordship, they have mentioned.
But thing is, Lordship, kindly peruse the page number 44, Lordship, their petition, Lordship.
It was fixed on 20/7.
24.
Which is the petition?
44. The prosecution has filed a petition.
Yes.
There is no specific grounds. They have not put any question. Only the grounds, Lordship, they have filed a petition. He has brought the Deepak Lahon as an informant in that case, as examined and cross-examined on dated 25/6/2000 discharge.
No, when this petition was considered, you were not present.
Yes, Lordship. In the meantime, Lordship, the date was fixed on 24/7/2024, and order was passed on 9/7/2024.
So on 9/7, whether you were present or not.
Yes,
Not,
Lordship.
Lordship. Copy was not received.
If Lordship will kindly come to page 16 for a moment, Lordship. Page 16, Lordship.
Yes.
Then you will find a petition, right? Petition number so and so has been filed by the APP with a prayer to re-examine so and so. Let a copy be furnished to the learned counsel of defense.
Yes,
Page so
whether
and so.
copies were furnished.
And Lordship will kindly see the date. It is order dated 26/6/24. Thereafter, Lordship, the order was passed on 9/7/24, if I'm not wrong. So ample time was given, Lordship.
No, copy was, there was a direction for furnishing of copy.
Copy was received on 24/7, Lordship, because we are reciting here, case was at the early Anglo, Lordship. During this period that they have passed the order. But evidence just speaks on 24/7 lordship. When we appear before them 24/7, we come to our knowledge that order already has 313(11) has been allowed. Without period. Without submission of the defense counsel.
Yes, Mr. Sharma.
Lordship, apparently this order is there, Lordship.
Yeah, but this order does not reflect that they were heard.
Lordship, other way around, Lordship,
Copy receipt order. Copy receipt order.
Let them be heard.
Lordship.
Let them,
Yes, Lord.
have you received the copy of,
Yes, Lord. On when I appear on the 24/7 to.
have you made any statement that you received the copy on 24th only?
Yes, Lord.
Where is this?
Adjournment on case number. Adjournment on 7, Lord.
Heard Mr. S. Deka, learned counsel for the petitioner. This application under section 528. What is 528? It is 482.
Yes.
Yes.
528 of the Code of Criminal Procedure of the BNSS slash comma 2023 filed by the petitioner Tarabir Gurung, impugning the order dated 9/7/2024 passed by learned Special Judge Karimganj at Difu in NDPS case number 1/2024 under section 18 within bracket B and 29 of the NDPS Act. Learned counsel for the petitioner has submitted that the petitioner is facing a trial in NDPS case number 1/2024 before the Court of Learned Special Judge Karbi Law. The petitioner has been facing the said trial remaining in custody. It is submitted by learned counsel for the petitioner that on 25/6/2024, the prosecution side examined one. Who was the PW1?
Deepak Lahan, Lordship.
One Deepak Lahan as PW1, and after his examination and cross-examination, he was discharged, and next date was fixed for examination of remaining prosecution witnesses on 24/7/2024. Stop. Learned counsel for the petitioner has submitted that, however, on 9/7/2024, when the date was fixed for production of the petitioner before the court, regular production of the petitioner before the court after 14 days, the prosecution side filed an application for re-examination of the PW1. The said application was registered as petition number 911/2024. He submits, learned counsel for the petitioner also submits that though the petition number 911/2024 was filed by the prosecution side on an off date, that is 26/6/2024. And though there was a direction by the trial court for furnishing the copy of petition number 911/2024 to the accused persons, to the defense side. However, as the next date of the case was fixed on 24. When it was fixed, when you received copy?
27/7 next date কি আছে 24/7 বলছে
20
on 9/7 লচ্ছে কি
24/7
9/7 2040 on that date was preponed lordship 22 to 22
24/7. The counsel for the defense petitioner did not receive the copy of the aforesaid petition. However, on 9/7/2024, which was the date for production of the
I think lordship it is evidence lordship overriding it was evidence lordship I think production and evidence
9/4.
9/4 when he was passed or order was passed on 9/7 and fixed on 22/7/2024 it was preponed date actually fixed previously fixed on 24 and production is next date is fixed for production and evidence. It is
And what
authorized.
happened on 22/7?
Lordship.
What happened on 22/7? Nothing happened.
As per order dated on 25th, I would have appeared on 20.
No, that I have understood. What has actually happened on 22/7?
I think the witness has not come up lordship, in that day.
No, your thinking will not help. You have to inform this court what actually had happened. Whether the PW1 was re-examined or not.
Next date was fixed on lordship, actually examination of.
No, do you know or not? Whether PW1 has been re-examined or not?
No lordship.
Not yet re-examined. Okay,
17 or 20.
last line.
Maybe the operator will believe it.
9/7/2024, the said petition was heard and allowed. It is submitted by learned counsel for the petitioner that on 9/7/2024, the petitioner's counsel had not received the copy of the petition number 911/2024, which he claims to receive only on 24/7/2024. And stop. Learned counsel for the petitioner has submitted that the petition number 911/2024 was allowed without hearing the present petitioner. And he also submits that. Where is the petition? At page?
44 lordship.
Page?
Page number 44 lordship. 44.
Submitted that in the petition number 9/11/2024, the prosecution side had not mentioned any specific reason for allowing the prayer for re-examination of PW1, still the trial court has allowed the said petition without hearing the present petitioner. Stop. I have heard the learned, I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor. On perusal of the impugn order dated 9/7/2024, it appears that there is no indication in the said order that the counsel for the defense side was heard before passing the said order. As the PW1 was already discharged after his examination and cross-examination on 25/6/2024. No, 25/6/2024, hence, before allowing the petition filed by the prosecution side, the trial court ought to have heard the defense side. Stop. When is the next date fixed?
I think Lordship 17 August.
17 August. On that day, you appear before the court. You have now received the copy of the petition.
Yes, Lord.
Stop. Learned counsel for the petitioner has submitted that he has received the copy of the petition number 9/11/2024 after the passing of the impugn order on 9/7/2024. Considering the above facts, this court is inclined to interfere with the impugn order so as to give a fair chance, fair opportunity to the defense side to oppose the prayer made by the prosecution side in the petition number 9/11/2024. Stop. In view of above, the impugn order dated 9/7/2024 to the extent by which it allows the petition number 9/11/24 is hereby set aside. The trial court is directed to hear the petition number 9/11 again on the next date fixed, that is on 17/8/2024, by giving a fair chance of hearing to the defense side on the said petition. This criminal petition is accordingly disposed of with above observation.
I please your lordship. Lordship, it's a petition under section 528 of BNSS for cancelling the proceeding of session case number 245. of the
Sessions
22.
case.
Lordship.
What is the ground?
Lordship, petitioner, it's a joint petition by the informant and accused. Lordship, both were husband and wife.
Okay. We issue
Annex
no-
3, please.
we are issuing notice to, oh, wife is also a joint petitioner.
Yes. You'll see the Annex 3, page number 31. It's a marriage certificate. Lordship, also, there is a one deed of mutual separation, page number 33.
Mutual separation.
Yes, first they separated, both were separated. Then they filed an mutual divorce petition before the Honorable Family Court. And from the Family Court, they have got the divorce. The divorce order is in page number 38.
You have furnished a copy of petition to the PP. Mr. Thakur, have you
Yes.
received?
Yes, my copy of the petition I have received.
30, page number 30, there is divorce order. And also there is an deed of compromise. Through that compromise agreement, they have settled all of their dispute and they do not want to carry any cases what is pending before any court.
Let him go through. We'll fix it for admission hearing. We'll admit it today. No. The respondent is only, or can we dispose it of today?
Otherwise, both
Sufficient
the
grounds are
parties,
there.
they filed this joint, your lordship, FIR is at page 12. Already, my lord, that page 38, my lord, he has pointed out that already that order regarding their divorce already passed by the family court, my lord. Your lordship can also dispose of point if your lordship can do.
After the divorce, lordship, the second petitioner already married to other person, living happily.
Okay. Then which is the non-compoundable offense involved?
Lordship, there is only one, that is 376.
My lord, sorry, my lord, I will have to go through it because 376.
376 is there.
There, my lord. On
Lordship,
Monday, my lord.
You go through.
Yes.
We'll admit it. We'll
No,
admit
lordship,
it.
lordship, check. The 376 only applicable if they are not husband and wife. They were husband and wife. Sufficient grounds are there. Lordship, it is not because FIR.
When the offense was alleged, at that point of time, they were husband and wife.
Yes, yes, lordship, yes. Before that, only problem arises, they were living separately because of non-supporting family. Both the family members, they were not supporting the petitioners.
No, my lord, only at that point of time.
No, let him go through.
Yes,
We'll admit it.
yes.
Lordship.
Mr.
If you see the lordship marriage certificate, you will see before the FIR. They married before the FIR. Okay.
Yes, my lord. Notice me.
Heard Mr. S. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor. This application under section 528 of the BNSS. Whether any record would be required?
Record may not be necessary.
May not be required.
May not be required because very initial stage, only appearing stage. Search has not been framed.
BNSS for quashing the proceeding of sessions case number 245/2022 arising out of PRC case number 2156/2021 and Khetri PS case number 100/2019 pending before the court of learned additional sessions judge within bracket FTC number 4, Kamrup Metro at Guwahati. Learned counsel for the petitioner has submitted that this petition has been jointly filed by the petitioner. Now they are divorced,
Divorce, lordship.
who were earlier husband and wife and have been divorced. It is also submitted that the offense alleged only 406 is non-compoundable.
No, 376 is also there, ma'am.
376 is non-compoundable.
Yes.
That the petitioner number 1 is facing trial for offences under section 120B/420/376/441/341/325/34 of the Indian Penal Code. Before in sessions case number 245/2022 before the Court of Learned Additional Session Judge number 4, Kamrup. Learned counsel for the petitioner has also submitted that the petitioner and the informant, who is the petitioner number 1, who is the accused, as well as the informant/victim, who is the petitioner number 2, have already settled the matter by an amicable settlement between them. It is also submitted by learned counsel for the petitioner that the offense under section 376 of the Indian Penal Code is not applicable and made out in the instant case, as at the time when the offense was alleged, the petitioner number 1 and petitioner number 2 were husband and wife in relationship. Stop. Then additional public prosecutor has received the notice on behalf of the sole respondent. Therefore, no formal notice need to be sent to the respondent. Let this matter be listed for admission hearing. When?
On my lord. 20th of 13th of August.
13th. On 13th of August 2000. 13th August. Yes. Quashing. I file quashing.
My lord, this is an application for
Atul.
under 311.
The lawyer say next item. Yes.
This is an application and we file under section 311, my lord.
311.
311 was rejected by the court below, my lord.
Your 311 petition was rejected.
Recalling of witness, my lord. Lordship may see, my lord. FIR, my lord. Page 26. The abatement of suicide, my lord. So
At what stage the trial is pending?
the trial, my lord, 3 of the witnesses examined, my lord.
Whom you want to recall?
The 3 witnesses, my lord, because
All three.
All 3, my lord. They have been examined in 2019 and thereafter no witness has been examined as of now. The last date was on 7/8/2024. The witness did not come. The trial court fixed the matter on 26/9. Long date has been given, my lord, and we informed the trial court also that we moved the petition before the High Court, my lord. But we have given the questionnaire also, my lord, that will be prejudiced if these questions are not put to the witness, my lord. In fact, my lord, lordship may see the evidence I have enclosed, my lord. Not a single suggestion has been given, my lord. Entire evidence, there is no single suggestion.
Suggestion by the defense side.
Yes, but we are cross-examining, my lord.
Now you want to fill up the lacuna.
No, not lacuna, my lord. The lordship, similar case, my lord, in Shillong High Court also had delivered a judgment, my lord, just to do this last month, my lord. I've got the judgment also, lordship.
We'll issue notice to.
And my lord,
It is,
proceedings, my lord,
no, we'll fix it before
before the date fixed. my lord.
the date fix.
Yes, and lordship will make it observation, my lord, that the petition will be disposed of, my lord.
Whether appearance of respondent number 2 would be required.
Yes, my lord. Requirement.
I'll leave it to your lordship.
Heard Mr. J. Roy, learned senior counsel assisted by Mr. D. Das, learned counsel for the petitioner. This application under section 528 of the BNSS, 2023 has been filed by the petitioner impugning the order dated 3/2/2024 passed by learned additional sessions judge number 1 Kamrup Metro in sessions case number 209/2018. Which dismiss the, by which the prayer for recalling of PW 1, 2, and 3 was dismissed by the trial court. Stop. Whether case record, anything would be required, records.
I will close the evidence, my lord. But only thing, my lord, draft questionnaire I have placed before the trial court, that may be required, my lord, because for your lordship perusal, my lord. If I have not annexed it with the petition, my lord. If I annex, then
Okay.
the purpose will be defeated, my lord.
Issue notice to the respondents since Mr. P. Borthakur has appeared for respondent number 1, no formal notice need to be issued. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post with AD as well as by usual mode. Let the scan copy of the case record of sessions case number 209/2018 be called for from the learned trial court. From the trial court, the registry shall take steps for requisitioning the scan copy. Let this matter be listed again on when should we list it?
My lord, 13th of September, my lord.
13th September. Let this matter be listed again on 13th of September 2024.
My lord, if case that it doesn't come, my lord, the interim prayer will be considered, my lord, because otherwise.
On that day you may. Today we will not pass any such order.
No, I don't want interim order, but lordship will make an observation, my lord. Otherwise,
No,
the trial.
why to bind someone who is, we don't know before which court it will come.
My,
So you may make a submission on that day for interim prayer.
at least what will be there, then it will be helpful for me to, my lord, pray for an interim order, my lord.
No, otherwise also you need no help. You can make submissions on that
Okay,
day.
my lord.
Because of this notification,
Yes, sir.
you have to follow this notification.
In that case, Lordship, may I file an IA right away and make a mention it to you?
Heard music.
Nine. Correction.
Will it come? It will, no, let it come up on Monday. You file an IA today itself. Heard Mr. S. Dutta, learned senior counsel assisted by Mr. P. Chaudhary. P.
Sengupta.
P. Sengupta, learned counsel for the petitioner. Learned counsel for the petitioner submits that the petitioner may be allowed to file an interlocutory application for making some amendment in the cause title of the case filed by the petitioner. The prayer is allowed. Let this matter be listed again on 13th of 12th August 2024. The petitioner may take steps for filing the interlocutory application for making necessary amendment in the cause title as prayed for before the said date. List this matter accordingly.
Item 30.
Wait, your lordship. Lordship, I have filed this quashing application, lordship, for quashing of the charge along with the orders passed in the case, lordship. Lordship, in this case, what has happened, lordship? There was a fight between two section of
For quashing of what?
the charge sheet along with the orders taking cognizance, lordship.
Offense under section
302.
2, my lord, 302.
So that is, lordship, may kindly listen to my submission once, lordship, if I may submit, lordship. Now, lordship, in this case, what has happened? There was a fight between two communities, lordship. And I was a scapegoat there. I was present in the scene because it was a masjid and I went for prayers. And at that point of time, my name was, I was present at that scene. Now, lordship may kindly see what has happened during the time of bail application which I have filed. Lordship would kindly see in page number 43 once, lordship.
No, we are issuing notice.
Yes, lordship. Lordship, my thing is that, lordship, if I may submit first, lordship. In this case, in the bail application itself, it has been stated that there is no implication of name. That is, I'm not on that, lordship. Now, if lordship may kindly see annexure 9, lordship, taking of cognizance, lordship. Annexure 8, how it has happened, lordship. Annexure 8. Now, lordship, this is a order passed by a SDJM, lordship. Annexure 8, lordship, may kindly see once. Peruse the charge sheet that so and so. The case is hereby transferred to the court of self, himself. Learned
Page number?
Page number 90.
Yes.
Learned magistrate may note that this order is purely administrative in nature under section 15(2) of the CRPC and has been passed without taking cognizance of the alleged offence by the decision of Honorable High Court in Rani Nora versus State of Assam. While therefore taking cognizance, learned magistrate has to comply with the directions of this High Court on so and so. Now, can the SDJM exercise powers under section 15(2)? Lordship may kindly see the CRPC, lordship. What is section 15(2)?
No, what is your ground? That
First of all, lordship, this order could not have been passed by the SDJM. Even though it has been passed under administrative capacity, it is the CJM who has absolute power under section 15(2) of the CRPC, not the SDJM. And then again, lordship, may kindly see what has happened on the very next day, 19(1). He has transferred the case to himself. And then this is the order which has been passed. CR is transferred on file for disposal. Peruse the case record. On perusal, I find it approved, proper to proceed with the case against the accused person, so and so. And in that, so many people are there. With that, my name is also there. Accordingly, cognizance is
charge
taken.
sheet was laid against you.
Yes,
That does not matter, lordship. I mean, that is what my.
No, today we are not going to hear all these things. We are issuing notice.
Lordship, I understand. The only thing that I want, lordship, let this matter go. But with regard to me, lordship, as far as my concern is that cognizance order may be at this moment.
Why?
Because that, lordship, I have this, lordship, because this is not how, there are hundreds of people are there. So many people are there.
There is no material against you.
There is no material against me. No, on that basis, if cognizance has to be taken, then there has to be a point that this is why I have taken cognizance against me. Now,
No,
cognizance
we'll
is
examine.
yes, lordship, may kindly see the judgment one, lordship.
Which judgment?
Paragraph number 11, lordship. I'm just coming to that. Lordship, paragraph number 11, lordship. May I just read?
Yes.
One of the courts open to the magistrate is that instead of exercising his discretion and taking cognizance of offence, the following procedure laid down under section 200 or section 202 of the code, he may ordered an investigation to be made by the police under section 156(3) of the code, which the magistrate did in this instant case. When such an order is made, the police is obliged to investigate the case and submit a report under section 173 subclause 2 of the code. On receiving the police report, if the magistrate is satisfied that on the facts discovered or unearthed by the police, there is sufficient materials for him to take cognizance of the offense, he may take cognizance of an offense under section 191(b) of the code and issue process straight away to the accused. However, section 191(b) of the code does not lay that a magistrate can take cognizance of an offense only if the investigation officer gives an opinion that the investigations makes out in the case against the accused person. Undoubtedly, the magistrate can ignore the conclusions arrived at by the investigating officer. Thus, it is a triad that the magistrate is not bound by the opinion of the investigating officer, and he is competent to exercise his discretion in this behalf, irrespective of the view expressed by the police in their report, and decide whether an offense has been made out or not. This is because the purpose of the police report under section 172 of the code, which will contain the facts of the discovered or unearthed by the police, as well as the conclusion drawn by the police from there is primarily to enable the magistrate to satisfy himself whether on the basis of the report and the materials referred therein, a case of cognizance is made out or not. Now, Lordship, this is where I put my case, Lordship.
Now, this is an order which is against revision lies, or you can come under 482.
I can come under 482, Lordship, because I have also challenged the charge sheet, because in one of my ground for challenging it is, Lordship, that the investigation has not done. With regard to me, there is no sufficient material, because it has always been the case that I went there for prayer. Now, suppose today in the court,
No, that needs examination.
That is examination, Lordship. I am not on that, Lordship. Because the prima facie, Lordship has seen how the cognizance has been taken. First of all, Lordship, on the very face of it, SDGM do not have the power under section 15(2). Lordship, may kindly see 15(2) once, Lordship, then it will be clear, Lordship, why I am saying so, Lordship. 15(2) of the CRPC, Lordship.
No, even if he does not have the power under 15(2), on the subsequent day, he took.
This is a subsequent this order of taking cognizance has flown from the order of 18(1), Lordship. He could not have done that. And if he have done it also, then it demands that he has to take cognizance with proper application of mind. He has simply written down what is written in the charge sheet. The names which are mentioned in the charge sheet, he has replicated it. And Lordship, this is also a cross FIR. What has happened in this case? Whoever has filed the FIR, everywhere he has taken cognizance. But that cannot be, Lordship, and this matter needs to be examined, Lordship.
We'll examine.
Lordship. And in the meantime, Lordship, my only praise with regard to me, Lordship, that
You have not been able to satisfy that regarding interim relief. We'll examine your contention. Heard Mr. P. Dekar, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section, whether it will be under 482 CRPC. That is again a question. It has to be under new provision.
Lordship, no, Lordship. Because, Lordship, this FIR has been filed in the year 2022.
But this application you are filing now.
Lordship, as per what I understood, Lordship, I may be wrong, Lordship.
No, I am not saying who is right, who is wrong. You have to assess this court. What is
As
the
per understanding, Lordship, when the
okay? An application under 482, it has to be under new provision.
Yes, ma'am.
Because 482 will be applicable only if the application is pending before coming into force of.
In that case, Lordship, I may be allowed to withdraw it. I'll file it with the new section.
You can amend it.
Let me withdraw it, Lordship. I'll file it with the new section.
Okay. So and so. Learned counsel for the petitioner prays for allowing the petitioner to withdraw the instant petition as there some typographical mistakes have crept in the petition and prays for allowing the petitioner to file a fresh petition. The prayer is allowed. This case is dismissed on withdrawal with the liberty as sought for granted.
Lordship. Highly agree.
এই কেস তো ঘুরাই দিব।
Lordship, I may be allowed to take the certified copy, Lordship. Lordship, that may be reflected in the order, otherwise they do not.
The petitioner is allowed to take back the copies of certified copy and annexed along with the instant application.
Highly agree.
An application under section 588 of the GNSS. Okay.
This is
Quashing
item number
of an FIR.
14.
Okay.
Okay, yes. What is the matter?
Okay, this is an application under section 528 of the BNSF. Okay. Quashing of the FIR dated 6/6/2024 and all women's police station case number 32 of 24. Lordship,
Where is the FIR?
FIR is at page 32, Lordship.
Relevant portion is page 41.
Page
51.
Page 41.
Yes. What is your submission?
Yes. Lordship, may I read the FIR?
Yes. Whether any accusation is made out or not.
Lordship, my
Has it-
humble submission is that pursuant to the FIR, a charge sheet has been filed by the has been filed against me under various provisions of law. My humble submission is that no prima facie offense is made out against me.
No prima facie offense.
Yes.
Okay.
Lordship, may I read the FIR?
The charge sheet has been filed under section 323, 354C,
Yes.
493.
Yes.
Yes. Please read the relevant portion.
Of the FIR, Lordship.
Yes.
Lordship, I am reading the entire FIR. Sir, I met once with Tapan Saha so and so upon Instagram, wherein Tapan Saha introduced himself. as-
You are Tapan Saha.
Yes. Wherein Tapan Saha introduced himself as 35 years, unmarried, and is looking for a bride. Over a period of time, Tapan Saha gained my trust, and as such, relationship developed between.
There was a scuffle between two groups, rival groups, pertaining to small petty businesses. A third party lodged an FIR. And you'll also find the FIR at page 25. I'm sorry, my lord, page 21.
No, this is her quashing of the charge sheet or.
Yes, sir.
Charge sheet.
Both the FIR as well as the charge sheet. And there's absolutely nothing, my lord. Your lordship will kindly have a look at the FIR, that's page 21.
But FR stage has been crossed.
They've just filed the charge sheet.
After investigation.
Charge sheet has been filed.
Okay.
Your lordship will kindly have a look at the FIR at page 21. Absolutely nothing. With due respect, I would like to inform you that today at 10/3/2024 in the morning, under the instructions of Mahesh Mittal, some of the members of so-and-so Unnayan Committee and Pukumara so-and-so society went to buy some materials needed by them for construction, and on the way they were obstructed by some of the accused named above, and the said accused had demanded rupees 20,000 from them. When they denied to give the money, they were attacked by sharp weapons by the accused, and resultantly one Mr. Soilendas was hit in the head with a sharp weapon, and as a result of which he fell on the ground. Somehow the members fled from the place to save their lives, and the accused followed them till they reached the police station. So this is our earnest request, etc., to investigate. Now, my lord, when we move the bail application, your lordship will kindly come to the order pass at page 31. Both this so-called person who was injured, Soilendas, as well as the complainant himself, informed the court that they have whatever misunderstanding was there that has been compromised, and they don't want to pursue. That your lordship will find at page 31.
No, but 302 is involved.
No one. Even
30
the it was never registered under 30. Your lordship will kindly come to page 25. The sections are 143, 341, 294, 325, and 427. And all of that was dropped when the charge sheet was filed. Your lordship will find the charge sheet at page.
Whether all are compoundable section? No.
Except one. In
Except,
fact, they have dropped everything else. If your lordship will kindly come to page 44.
except 384.
And there were 8 accused. Against 5, they found absolutely nothing. And so far as the other 2 are concerned, other 3 are concerned, your lordship will kindly come to the charge sheet, page 44. At page 44, they narrate the contents of the FIR, and the relevant portion your lordship will find at page 45. What they say is this matter at page 45. During investigation, it is found that the following FIR named accused persons are not involved in the case. No evidence found against them. 5 are dropped. And thereafter, in course of investigation, a prima facie case is well established against Polen Kolita, Vedanta Das, and Manoj Thakuri, etc., all residents of so and so Soigaon, for commission of offence under section 323 and 34.
And 294 is there.
No, Malad. 294 also has been dropped. Yeah, I'm sorry, Malad. It has 294 subsequently added by hand.
Yes.
But where are the ingredients? There is absolutely nothing. And most importantly, your lordship is aware of the Supreme Court judgment. Once these petty offences, and in fact, now your lordship is aware, the government itself has taken a policy that any petty offences there are being, the public prosecutors are all withdrawing. And there's a judgment I would like to rely on, one very short judgment.
No, whether now the persons who are entitled to who can compound these offences, because both the offences are compoundable offence. 294 is compoundable or not?
294 is also compoundable.
Then they have to approach the court that we have compounded the offences.
That is true, but however, on the face of it, there is nothing that is made up. The lordship will.
No, you are saying from the beginning that there is nothing. But after investigation, the IO found materials under 323 and 294. So there is something is there. Now, if a compromise is already arrived at between the parties.
That was what was submitted when the bail application was moved. So in that case, my lord, may I suggest this? Your lordship will issue notice with notice on the interim. We have made the complainant also a
Let
party.
them come.
Let him also come.
Okay.
And your lordship will issue notice on the interim.
Okay. Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr. T. Das, Learned Counsel for the petitioner. This application under section 528 of BNSS, 2023 has been filed by the petitioners 1, 2, 3, 4. Nam Didi, 1, 2, 3, 4. Praying for quashing of the charge sheet, quashing of the FIR, as well as charge sheet number 74/2024, dated 31/3/2024, filed in connection with Soigaon PS case number 97/2024. Under section 294/323/34 of the Indian Penal Code. Issue notice to the respondents. Since learned additional public prosecutor has received notice on for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice in this case, as well as regarding the interim prayer made by the petitioner in this case to the respondent number 2 by registered post with ID as well as by usual mode within 3 days from the date of this order, returnable on which date?
Your lordship may have it on either 6th or 11th.
Returnable on 11th of September 2024, list accordingly.
Your lordship may just observe that the interim will be considered on the text.
We have issued notice for interim.
Obliged.
Please, the lordship, this petition is filed for quashing of the gross FIR, my lord. No, what happened?
Gross FIR.
There is a land dispute between the parties. I filed my FIR, my first FIR is at page 18, my lord. Page 18, annexure 3. It was lodged on 2/5/2024. English version with deed as per I beg to state that on 1/5/2024 at around 9 p.m. when the cousin brother of the informant Asiruddin Sheikh, son of late Ansar Ali, returning back to his house from Mama Bajar, the below named accused person surrounded him from four corners and killed him by beating. Thereafter, they threw the body of the deceased in a water canal at Sagunmari Part 4 near the house of the deceased. It is to be mentioned that a land dispute case is running for a long time between the parties before the Municipal Court, Bilashipara. In that situation, the accused person had threatened to kill by assaulting. On 2/4/2024, the deceased elder brother Rihul Amin was beaten by the accused, and they also tried to beat Asiruddin, and therefore an Azhar lost before the Bilashipara police station. So the informant is bound to lose the effort to take legal action against the accused. On the basis of the said affair, the police has arrested one Motiur Rahman, annexure 4 forwarding report. That is on 3rd May 2024.
Now, which FIR you are seeking to quash?
12/5/2024. That is
Page?
annexure 5, page 25. It was lodged after 10 years of the after 10 days of the first affair.
Page 25.
25. And interestingly, both the affair was lodged under same police case number.
Now, what is your ground for?
Second affair was lodged. It is an afterthought affair, and it was nullified
But
intention.
that will be found out only during investigation.
No, my lord, Supreme Court, there is a Supreme Court decision, on, and it was made only
It is in regard to the same incident.
same incident.
Then second FIR would be regarded as
Yes,
162.
162.
Once
Once maybe it is 161.
161 statement barred by once.
Supreme Court decision is paragraph number 26, my lord. Para 26.
And here, my lord, she is praying for quashing of the present affair, that is
Yes,
Bilashipara PS 109/24.
Affair dated 12/5/24 because both the
12/5/24
affair was lodged.
because offenses are.
Whether a separate case was registered.
No,
In this case, my lord, section 120B 302 325 34.
both the affairs was lodged under same police case because
No. On the basis of the subsequent FIR, whether a separate case was registered. Then which case was registered?
my affair was lodged as Bilashipara PS case number 109, and second affair was tagged with the first FIR, And it was reflected from the order of this honorable court where the on the expressions of my affair approved before this honorable court for bail application, it was reflected, your lordship may kindly.
My lord, if first FIR, he is, my lord, before this honorable court against the, my lord, FIR dated 2/5/24. If this is the FIR.
2/5, no.
No,
He's,
I'm
she's,
12/5,
she's
2024.
submitting, I have not gone through. That she's bringing quashing of 12/5/24.
My lord, in the cost title, it is specifically mentioned, my lord, FIR 109/24.
12 for quashment of affair dated 12/5/2024.
But that is not regarded as FIR. Question of quashment will not arise.
Yes, yes, my lord.
Because it will be only treated as a statement given
Yes.
after lodging of the
Yes,
first
yes.
FIR.
Yes.
If on the basis of the second FIR, no police station case has been registered, then
Now, your lordship may kindly came to page number 49 of the bail application, bail order of this honorable court. Page number 49. Paragraph 4.
yes, paragraph.
Paragraph 4, the learned additional purpose is submitted that the case date has been received, which clearly reflects that both the affairs are registered as Bilashipara PS case number 109 of 2020.
Now, my lord, both,
So both cannot be registered.
Yes, my lord, both are registered as per case date.
The subsequent FIR will not be treated as an FIR. It cannot be quashed because
Yes,
on
yes.
basis of that, no PS case has been registered.
and my lord, both cases are now tagged, and my lord, only one case, my lord, 109/24.
That will be treated as a statement recorded during investigation.
Yes.
Huh?
But this reflect that both the case was registered as Bilashipara PS case number 109 of.
There cannot be two 109
Yes, my lord.
cases.
So there is
on
requirement for any quashing of.
quashing is not.
But
Now there is no question of any second affair, both are
but
tagged,
which
my lord.
person is harassing me and pressurizing me to withdraw the first FIR. Therefore, I proceed.
Withdraw which FIR?
First FIR 252, which was lodged by me.
No. What is the stage of investigation in that FIR? You file a complaint against police if some police is harassing you.
Yes, sir.
Yes, already have filed me. Lord.
But this is on the basis of this case, FIR, subsequent FIR, no fresh police case was registered.
Yes, ma'am.
Police case was registered on the basis of 2/5, the FIR filed by you.
Yes.
In that case, this second FIR filed by the other side has been tagged with.
Tagged with.
So that is not an FIR for 109. Because 109, case number 109 was registered on 2nd of May. And the FIR which you are intending to quash was filed on 12th of May.
12/5.
So police case was registered prior to that.
Yes.
So question of something which has come after 10 days of registering police case cannot be regarded as a FIR. No case.
But on the basis of this, my lord, police is harassing me. Your lordship, I will take instruction. Your lordship will comment on next week. I will take instruction. My lord.
There is nothing.
Yes.
Nothing is there. Now, what is your submission? What should I do?
Well, otherwise, my lord, my prayer before your lordship, this petition is liable to be
Liable to be dismissed.
dismissed. My lord.
Next, I will take
Liable to be
instruction.
dismissed.
Okay, let her seek further instructions.
Otherwise, your lordship may kindly come to the cost title of the present petition. Here specifically mentioned for quashing of the PS case number 109/24.
I have
If in
mentioned FIR dated 12/5/2020.
at the motion it says some confusion at the first point of time without going.
So
into
let her,
details.
otherwise what you have submitted, from that submission, it appears that you don't have a case in.
Yes.
No, my lord, it
But
is
you can,
afterthought affair and it
okay,
was-
heard Miss S. Roy, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. Learned counsel for the petitioner prays for an adjournment or seeking some instructions before she makes
14th, my lord.
submission in this court. Let this matter be listed again on 14th of August 2020.
Hello, sir. The petition is active matter order for the additional premium matter looking for issuing non-valuable warrant of arrest matter on 18/6. When can I have a look on page 26? The last one.
What is the offense?
Offense was T41, T23, 506. And can I have a look at page 26, first one?
Yes.
Page 26. Well, order dated 30/2022. Both petitioners are present, and next date was fixed on 18/6. And next page, this is my impugn order, page 27.
Just a minute, just.
Sir, NBW was issued, on that day, he was not appeared.
You
Because,
defaulted on
Hello?
page 26, you were there.
Page 26, he was present. And next date fixed on 18/6. And on 18/6, he was not present, and NBW was issued, madam. And one of the accused, he was arrested on the basis of this order. That's why the petitioner is accused.
One of the accused was arrested.
Yes. Sir.
Thereafter,
After now, he was taken custody, madam. After that, after 7 days, he was released.
no, where is the error in the order?
No, there is no error, madam. I am not on that thing, madam.
Then this petition is liable to be dismissed if there is.
No, madam, because madam, due to my daughter's health condition, madam.
But you have to inform the court.
I was in Chennai at that time, at point of time. Madam, due to mental pressure. madam.
You cannot be in Chennai without informing the court
I have annexed the medical documents, madam, of my daughter, madam.
before this court, not before that
No,
court.
At that moment, madam, my mental condition is not, madam, I have forgiven that case, madam. You know, madam, all along, madam, I was appeared, madam. I was participating, madam, in the proceedings. You know. I am given a assessment, I will appear, madam. That's the time, madam. Because only one day, madam, he was not appeared, madam, and he was, NBW was issued, madam.
Yes, Mr. Bhartak.
Let him file an appropriate application before the trial court by annexing all these medical documents, and then trial court will consider.
But trial court, madam, has not considered, madam, another under accused, madam, same case, under accused. He was
No, you surrender before trial court
definitely I will send up.
and make prayer before this trial court. When is the next date fixed?
Next date fixed on, madam, 16/8.
You appear before the court on 6th.
Appear, madam. But the protection will be given, madam.
Heard, Mr. A. Khonikor, learned counsel for the petitioner, also heard Mr. P. Upadhyay, P. Bhartakur, learned counsel for the learned additional public prosecutor. This application under section 528 of the BNSS, 9, 2023 has been filed by the petitioner, namely Partha Pratim Hajorika, alias Partha Hajorika, impugning the order dated 18/6/2024, passed by learned additional Chief Judicial Magistrate, Lakhimpur, North Lakhimpur, in PRC case number 2887/2017, whereby the trial court had issued non-bailable warrant of arrest against the above named petitioner. Learned counsel for the petitioner has submitted that the petitioner is facing a trial in PRC case number 2887/2023 under section
T41, T23,
341/323/34
506.
/506 of the Indian 34 paragraph 506 of the Indian Penal Code before the Court of Learned Additional Chief Judicial Magistrate, Lakhimpur. It is submitted that the petitioner was regularly appearing before the trial court. However, on 18/6/2024, he defaulted due to, why you defaulted?
Because
Who was ill
my daughter,
due to the,
Devolina Hazarika.
due to the illness of his daughter? And on that day, the trial court issued non-bailable warrant of arrest against him. Stop. Learned counsel for the petitioner has submitted that the petitioner was prevented by genuine cause of, that is, ailment of his daughter, from appearing before the trial court on the date fixed, and he is ready to face the trial. Stop. Learned counsel for the petitioner has also submitted that the next date of the PRC case number 2887/2017 is fixed on 17/8. 16/8, and he's willing to appear before the trial court on 16/8 and seeks some interim protection so that he may appear before the said trial court. Stop. Considering the submissions made by, I have also heard Mr. P. Bothakul, learned additional public prosecutor. Considering the submissions made by learned counsel for the petitioner and grounds shown by him, this application under section, what is the 528 of BNSS is hereby disposed of, with a direction to the petitioner to appear before the trial court on the next date fixed, that is on 16/8/2024. Stop. To facilitate his appearance before the trial court on the next date fixed, the operation of non-bailable warrant of arrest issued by the said court against the present petitioner shall remain suspended till 16/8/2024. On his appearance before the trial court, the petitioner may pray for any relief to which he is legally entitled to. With above observation, this criminal petition is disposed of.
Diplomas.
Lordship, respondent herein lodged a complaint before the additional district magistrate Kachar at Silchar. They are under section 145 and 146 of the CRPC, Lordship. And learned court.
145 before DC, additional
Lordship,
DC.
additional ADM, additional district magistrate.
Okay.
Learned additional district magistrate passed the order, Lordship, on 12/1/2023, thereby declared the possession in favor of the first party.
In favor of the respondent.
No, Lordship, in favor of the first party complainant, that is here present respondent.
Okay.
So, Lordship, petitioner referred in revision petition before the Lordship learned session court. Session court also upheld the order passed by the learned ADM. Agreed by this petitioner before this honorable court on the two ground, Lordship. Firstly, police report was not called for.
Whether
Second,
482 lies,
Lordship,
this, an application under this provision lies 528. Is it maintainable or not?
Lordship, yes, sir.
This, your application
Lordship.
against the, I'm just putting a query. Application under section 528 of BNSS
Lordship.
is maintainable against a order of revision. Yes or no?
Yes, maintainable. Earlier it was it is maintainable.
Okay.
Second division is.
Then
not
we are,
maintainable.
we are issuing notice.
And the lordship executive order may be stayed lordship. Otherwise, there is a police report, so what not,
No,
call for
impugn order will be stayed,
lordship.
will be considered after, because private parties are involved,
Yes, lordship.
after service of notice on them. Heard Mr. L. R. Majumdar, learned counsel for the petitioner. This application under section 528 of BNSS 2023 has been filed by the applicant impugning the order dated 9/5/2024 passed by learned additional session judge within bracket FTC Kachar in criminal revision number 83/2023, whereby it upheld the order dated 12/1/2023 passed by learned ADM Kachar in MR case number 558/58M/2008, declaring the possession of the disputed land in favor of the respondent number 1. Issue notice to the respondents and call for the case record of criminal revision number 83/23 from the Court of Learned Sessions Judge Kachar, as well as case record of MR case number 58/2008 from the concerned court. As learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD as well as through usual mode, returnable on 20 September 2024. Registry to take steps for requisitioning the case records from the trial court, from the case records as directed here in above, list accordingly.
Right.
Item 21. Wait, please, your lordship. The 482 bail application, anticipatory bail application, my lord. Petitioner before your lordship, my lord, is the president of the Gaon Panchayat, that is cooperative society, my lord, is the elected member, my lord. And your lordship kindly see, my lord, there is a show cause notice issued by the district commissioner to him, my lord. That is page 25, my lord. Regarding distribution of, my lord, PDS rice to the fair price shop, then fair price shop to the beneficiaries, my lord. So your lordship kindly see there is the show cause notice which was issued on, my lord, 22/5/2024 at page 25, my lord.
Yes.
May I read it, my lord? Show cause notice.
Okay, what is the?
My lord, there is a, my lord, delay in, my lord, supplying the food, rice to the some five school, my lord, for midday meal, my lord. Because that was not collected by the, my lord, school authority, and that was found in my excess 41 quintal of rice found excess in our godown, my lord. And that's why the show was made, my lord. Apart from, my lord, another 2 allegation also there. Then I will give a reply to the show cause notice. And after that, my lord, your lordship kindly see the fair price shop, my license has been cancelled. Your lordship kindly see order dated 10/6/2024, annexure 5 page 31.
No, you said you are elected
I am
president.
elected president of the, my lord.
Which license of this Gaon Panchayat Samavay Samiti?
Yes, my lord. No, my lord, nowadays, my lord, you have to fair price shops, my lord.
You have your own fair price shop.
No, I am not fair price. I don't have any fair price shop. Now, my lord, so Gaon Panchayat, that is GPSS, my lord. That Gaon Panchayat, my lord, that Samavay Samiti.
Yes.
So Samavay Samiti, it goes to the fair price shop and then fair price shop to the beneficiary. So that allotment will be made, my lord, by the Food and Civil Supply Department to the, my lord,
Samavai Committee, and Samavai Committee sent it to the fair price shop and fair price shop to the beneficiary. But those who are my school, my for midday meal rice, they directly collected from, or it is a my lord now, as part of that scheme, my lord, it has to be doorstep, it has to be my lord supplied by the Samavai Committee. In respect of the my lord school, the 5 school under my Samavai Committee, my lord, and there is a my lord delay in my lord supplying that midday meal rice, and then the complaint was lodged, and it was delayed because my lord, for 1 bag cement we cannot provide a car to my lord. That's why my lord, that the headmasters are agreed that my lord, in 1 day, that my lord, all the 5 school my lord, in 1 go they will be supplied to the. So that was that I have a next the complaint also, my lord, that is there, my lord. But there is an inquiry made by the Food and Civil Supply Department. After the inquiry, they found that yes, there is a irregularity. That's why they suspend my license. Suspend that. Your lordship kindly see that my order at page 31, my lord. Last but 1 para. Under the above circumstance, the PDS sub wholesale license, PDS so and so, EPS is hereby suspended with immediate effect. In the interest of beneficiaries, the fair price shop MS so and so will be attached with the another second. So that was the inquiry report. That was the order passed by the Food and Civil Supply. Then, my lord, the FIR was lodged. Your lordship kindly see at the FIR, my lord.
At page
36, my lord.
yes.
Page 36, the FIR, my lord. FIR was lodged against my lord, secretary and president of the my lord, Samavai Committee, my lord. Nagarband, Gram Panchayat, Samavai Committee. So accordingly, Nagarband. Accordingly, my lord, case has been registered under section, my lord, 315, 3164 and 3168, 3184, my lord, and 320. 320 is bailable, my lord. 315 is not applicable to me, and 316 and 3184, my lord, BNS, my lord, BNS, my lord.
Yes.
So, my lord, my submission before your lordship kindly see. Now, my lord, already my lord.
No, what ultimately happened? Ultimately, to these 5 schools,
No, that
whether
is now it is withdrawn from us, my lord. We cannot now, my lord. No, 5 school, my lord.
there was a delay,
There is a delay, my lord.
but their supply was made.
No, there surely, my lord, there was a delay, my lord, and that's why, my lord, that stock was found in my godown, my lord.
Okay.
41
It
quintal.
was not
that was found
delivered.
in the my lord. I have given explanation to the my lord authority, my lord, and but they are not satisfied with my explanation. They cancel my license, suspended my license, not cancelled, suspended my license, and that is attached to another, my lord, another GPSS, my lord. So that is continued. Now, my lord, in the FIR, your lordship kindly see, and the same fact, my lord. Now, my lord, FIR has been lodged, and my lord, your lordship kindly see, my lord, the new section 3164, my lord, of BNS, my lord.
What
That
is 316?
3164.
Corresponding to
Corresponding to, my lord, yes, my lord, 316.
405.
405. Okay.
Criminal Bishop Trust, my lord, by a clerk, my lord. So we are not, my lord, DPS, Gaon Panchayat, president of the Samavai Committee is not, my lord. Under 316, you will not, that the ingredient of this whole section will not attack, my lord. Because there's 3164 and 3184 is non-bailable. Others are bailable.
Okay.
So your lordship kindly see, my lord, 3164, my lord.
Criminal breach of trust.
Criminal breach of trust.
And what is 318? Cheating.
318, my lord.
So 406 and 420.
Yes, corresponding.
Of the earlier law. Now, what is your submission?
My submission is, my lord, already, my lord, my license has been my lord, that is, my lord, suspended, my lord. And now, my lord, your lordship kindly see that only that regarding stock, but it is there, my lord, what is the stated in the FIR that it might maybe, my lord, sold in the outside the beneficiary, my lord. Not goes to the beneficiary, that whose was found in my lord, my Gudan, 41 quintal of rice, my lord. That might be kept for sale in the outside the fair price shop, my lord. Not in fair price shop.
Now, where
That is assumption and assumption and presumption, my lord, they have filed this FIR. Now that 41 quintal have already been seized, my lord.
seized? This
Seized,
has
my
been seized. Okay.
Seized and it is attached to, my lord, another fair price shop.
Okay, yes, Mr. Bhattakur.
Yes, my lord, from the contents of the FIR, DRD, my lord, he is the president of that, my lord, GPSS, my lord. And my lord, here from the contents of the FIR, it's specifically, my lord, only after physical verification of the stock, my lord,
Correct.
in the godown, it is found that some of the, my lord, some of the stocks which are not actually supplied to the godown, my lord. Why they stocked all those, my lord, PDS rice in that godown, my lord? For which, my lord, thereafter, my lord, specific allegation is that, my lord, those PDS, my lord, rice, which were meant for, my lord, under various schemes of the government, my lord, midday meals rice, and for distribution for other, my lord, schemes unto various poor beneficiaries, my lord. And now, my lord, there, my lord, there is also allegation, my lord, regarding, my lord, your lordship may kindly come to page 37, last two paragraph, my lord. The secretary and the president of so-and-so GPSS distributed some blank PS ration cards to some beneficiaries who were not selected as beneficiary as per norms in lieu of illegal money, and thereby contravene terms and conditions of so-and-so under some public distribution orders of the same order. And next paragraph, my lord. The one Ajibur Rahman and others submitted a complaint before deceased Morigaon so-and-so alleging that secretary and president of Novograha GPSS misappropriated an amount of rupees 53 lakhs only from the GPSS fund and requested for recovery of the misappropriated money and to initiate legal action against so-and-so for misappropriation of the, my lord, somewhere on this fund.
My submission on that.
Thereafter, my lord, last portion. So the secretary and president of Messrs so-and-so are involved in malpractices of midday meal rice and PMG KOI rice and misappropriation of GPSS funds, and the whole matter needs a proper police investigation. So, well, being a public servant, they both the president and secretary, those are, my lord, rices are meant for my under some schemes of the state to some of the beneficiaries, my lord. Those are poor beneficiaries, and some of the midday meals rice for distribution to various schools. So those, my lord, rices are, my lord, the money fund also misappropriated. And
fund is, my lord, your lordship kindly see that is GPSS fund, my lord, indeed, and after
And
audit,
also-
my lord, that will be come to, my lord. That is not in the even my focus notice, my lord. Who is lodged this FIR, my lord? This is FIR by the government officer, my lord.
And there is also allegation of illegal diversion of those, my lord, PDS articles to, my lord, open market, my lord.
That is presumption, my lord. Your lordship kindly, my lord, see the language of the FIR, my lord.
That is accusation. It is alleged.
Alleged.
So only
Mr. Ahmed, you are also appearing. You are.
I am just, made over one document, sorry, Lordship, may I kindly see?
Who is he? I don't know, my lord.
I am the
Yes.
person who initially lodged the complaint before the
No,
deputy.
my lord,
commissioner.
he is not
That-
complainant, my lord. He is
that
not
I have-
complainant, my
I
lord.
am the beneficiary,
My
lordship, that the voter list I have also having lordship, that lordship.
Then, my lord, it will be floodgate, my lord.
I am the.
If you, my lord, complainant come before this honorable court, no problem, my lord.
And in terms of the victim.
But this is
petition, I
affair
also
lodged by
fall
the
under
government officer.
victim category, lordship. That initial complaint was filed by this Ajibur Rahman and others, lordship, being shareholder. That first page, your lordship will find that complaint.
Whether you have a right to oppose the bail. You are not the informant.
I'm the one of the victim because I am the shareholder of that GPSS, lordship, and misappropriation also caused, lordship, injury to me also. And one thing, lordship, that they approached the learned session judge, that order, lordship, I have given at page 4. After
Who can oppose a bail prayer?
Normally, my lord, by the complainant.
What is the law?
The law is, my lord, but so far I know, my lord, the complainant can, yes, they can oppose, my lord. Then, my lord, if your lordship, anybody can, my lord, your lordship kindly see para 8 and 10 is very important, my lord, because I am the president, my lord, my vice president is behind me, my lord. And my lord, he is doing all these things, my lord, because he want to become a president, my lord. In para 8, I have clearly stated, my lord. My lord, if your lordship allowed, my lord, anyone, my lord, other than the complainant, my lord, it will be a floodgate, my lord. And that too, there is some procedure, my lord. That rule of law has to be followed, my lord.
Yes.
Anybody come and guess, I am opposing, my lord. That, my lord.
Lordship may fix it on Monday. By this time, I will file application for impleadment, Lordship.
Yes, unless you are impleaded.
Because otherwise, victims have right to participate in any proceeding. That is Jagjit Singh's judgment.
But this is a, my lord.
Now then, who is a victim? That question will arise in such
Because
cases.
the FIR was laws on the basis of my complaint. That is the first page I have given, Lordship.
You file an application.
By Monday,
We'll
Lordship.
take it up on Monday.
My lord. Till then, my lord, I may be protected, my lord. I am a respectful person. I am the president of the, my lord.
Because session judge, learned session judge rejected after perusal of case dialogue. My prayer is that still the may not be. That page 4, Lordship may.
Okay, no, till Monday, the protection may be granted. Because he may be arrested even tomorrow. So till Monday, we are protecting him.
Protection, no coercion, that may be granted. Bail may not be granted, Lordship.
My lord, his right yet to be acquired, my lord. Then the PP can oppose, my lord.
Yes,
Otherwise, my lord.
the question of procedure is there. Unless you are included, unless you show your locus standi that
Those documents I am having, Lordship. Those documents I will bring on record. That is the only thing.
we are deferring it till Monday. Till then,
I am be protected.
heard Mr. T.J. Mohanta, learned Senior Counsel, assisted by Mr. J.C. Bora, learned counsel for the petitioner. Also heard Mr.
P. Whatever.
P. Bhattakur, learned additional public prosecutor. During the midst of hearing of this anticipatory bail application, Mr. A. Ahmed appeared and submitted that he wanted to oppose the bail application representing one of the victim of this case and prays some time for filing an impleadment application in this case. The prayer is allowed. Let this matter be listed when?
Monday,
Let this matter be listed again on 12/8/2024. For in the meanwhile, the Mr. Ahmed may file application as desired by him. So, considering the facts and circumstances of this case, till the next date fixed, that is till 12/8/2024, no coercive action shall be taken against the petitioner in connection with Lahori Ghat PS case number 142/2024.
My lord, while your lordship has already granted interim, then my lord, CD may be called for and fixing it on 16th. I will.
Whether CD will come?
Then my lord, fixed it on 16.
No, we are not granting interim.
Yes.
On Monday, it is question of one day in between.
Yes. Then your lordship may also CD may be called for. I will try to get it if possible.
Okay. Also call for the case diary of.
Otherwise Tuesday, my lord, Tuesday I can try to do.
Okay, let us fix it on 13.
My lord.
Let this case be listed again on 13 for case diary.
May I please your lordship? My lord, here is bail application, my lord.
23 na 22? 22 to 9.
My lord, here, my lord, allegation, my lord, is that my lord, husband of the my lord, wife, informant, my lord, was missing, my lord. Thereafter, my lord, dead body was found. And my lord, three persons are named in the affair, my lord. They were arrested, my lord.
No, this you have filed under section 438. It has to be under new provision.
New provision.
Bail has to be filed under new provision.
But because my lord, offense was committed earlier, my lord, that is why.
No, but applications have to be filed under new law.
My lord, my lord, correct, my lord, that first title, my lord, if allowed.
Heard Mr. S. Hawk, learned counsel for
Yes,
the
Sikdar, my lord.
S. H. Sikdar, learned counsel for the petitioner, who prays for making amendment in the cause title of the application filed by him. The prayer is allowed. You make amendment as per notification number 79. The petitioner may make amendment to the cause title as per notification number 79 issued by the registry of the court on 19/6/2023. List this matter again on 13th of August 2024.
Published.
Item 24.
My please, Lordship. Lordship, in this case, the petitioner, my lord, is not named in the FIR, my lord. And the police has filed the charge sheet, my lord, on suspecting, my lord, and showing him absconder, my lord. Some co-accused has been arrested, my lord, and the learned magistrate court, my lord, not allowed the bail of the arrested co-accused on the ground that the section is exclusively triable by the court of session, my lord.
364.
364A, my lord.
What is the punishment?
That is life imprisonment.
Okay.
So, my lord, this is the problem, my lord. 64.
When is the next date fixed?
My lord, the next case is not yet committed, my lord.
When is the date fixed by the committal court?
My lord, date
A date is fixed before the court,
that is not known to me, my lord.
whether processes have been issued against you, non-bailable warrant.
Yes, my lord.
What is the
Non-bailable warrant
date of
is issued.
appearance?
That is, my lord.
We'll call for the scan copy of the case diary.
Yes.
If materials are there,
Next date, my lord.
heard Mr. B. Chanda, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. This, what is the provision for pre-arrest bail in new law? 482 or 480?
482, my lord.
482.
And earlier it was 438, my lord.
This application,
Also, my lord, here also under 438.
he has made corrections by hand.
My lord, I have corrected by hand, my lord.
Under section 482 of the BNSS, 2023, by the petitioner Krishna Laskar, apprehending his arrest in connection with PRC case number 1485/2019 pending before the Court of London. Judicial Magistrate First Class Hojai, Devnagar. Stop. Perusal of the scan copy of the case diary would be necessary for considering the instant bail application. Hence, call for the scan copy of the case diary from the Court of London.
SDJM, my lord, SDJM Hujai Shankar Devnagar.
London SDJM Hojai. You have written JMFC.
Lordship, there it is one copy, it is one SDJM is there, my lord.
From the
Oh.
From
Order, earlier order has been passed, my lord, JMFC, my lord.
from the committal court. Let this case be listed again on 19th of August, 2025.
My please, your lordship. The item is possible for the day.
For the day,
Day only. May fix it on Monday.
heard Miss J. Brigham, learned counsel for the petitioner, who prays for an adjournment due to on the ground of personal difficulty. The prayer is allowed. Let this matter be listed again on 12th August 2024.
I mean, I don't know, 51
May I please, Your Worship? Application for regular bail application, my lord. I am in custody for last 6 days. My lord, the FIR 8 page 20, my lord. Frankly speaking, my lord, after going several times of this FIR, my lord, I couldn't make out what offense being committed or whether any offense being actually been committed by anyone. But it appears that, my lord, it is on the assumption or the in apprehension of the offense, my lord, this person being arrested. Now, Lordship will find at page 20, these with the references subject cited that I have honored to report as per page 20, my lord.
Yes.
With references to subject cited, I have honored to report that as per above noted GD entry reference today dated so at so PM information received as per reliable sources that a group of culprits belonging to the nexus of the smugglers on the theft, committing theft of the oil from the oil tankers and freight with the diesel from the government public sector oil refineries of Assam, meant to be transported to the petrol pumps surrounding Nagaon and other parts of Assam. Through the conspiracy and the organized plan to commit such other theft, another theft at place within the so-and-so PS jurisdiction. Now, this is very important. Through the conspiracy, we organize a plan to commit such a theft at a place within the Uloni PS jurisdiction for the same in the name of managing the superior police official Nagar district in felicitating and helping them in committing such crime within Nagar district. One of their accomplices named Ibrahim Ali and Rakibul Huda took 2,50,000 who would help them to manage high police official Nagaon district. On getting information about the movement towards the Uloni PS managing OC Uloni PS cost of rupees 1 lakh, the accused person apprehended at Uloni PS by the undersigned, namely Jamaluddin so-and-so, Alam Ali so-and-so, Sri Abdul Khalis, involved and recovered cash rupees 1 lakhs in Vivo Mobile and 1 Vivo Mobile, 2 numbers of Oppo Mobile and Suzuki Swift Desire car being number so and so, 1 Kia current car being so and so from their possession, and such theft and their nexus resulted in this loss of the revenue to the government exchequer. Which theft I couldn't understand, madam. During the inquiry, it came to know that the accused number Jamal Ahmed collected rupees so and so, but this is the allegation against me, that the Jamal Ahmed collected rupees 2,50,000, out of which Sultan Sheikh of Harmoti Bagori paid 80,000, Tahir Ali paid rupees 1 lakh, and the accused number 1 Jamal paid 70,000, of which amount was paid to accused number 2 Rocky, to accused number 3 Ibrahim, to manage their police or higher authorities. Under the above facts and circumstances, the below noted accused person committed offense of cheating, attempt to commit the theft of petroleum products. Where is the offense of the theft or the petroleum product, madam? Organized crime, etc. At the below noted accused person previously involved with the theft petroleum product from the oil tankers oil so and so, ammonia area and so and so. Now, my lord, this is the FIR. Now, name of the address of the apprehended person, my lord. That is the apprehended person. So, now clerkship can see name of the address of the apprehended person.
Yes.
1, Jamaluddin. Number 2, Rakibul Huda. Number 3, Ibrahim Ali. Number 4, Alam Ali. Then number from Tahir Ali, so and so, so and so. As per this FIR, these are the 8 numbers of person being apprehended. But I was not apprehended, my lord. There.
Your name is?
My name is, my lord, Rakibul Huda. I was not apprehended, my lord. Now, what is the...
No, your name is Rokibul.
Yes. Subsequently, I have
Rokibul or
surrendered.
Jamal?
Rokibul.
Rokibul.
Huda. Subsequently, I have surrendered because of this FIR to the police station. And thereafter, I have been forwarded. I have appeared on, this is Lordship will find my forwarding, page 24. That is my forwarding, my lord. Now, from this FIR, what appears to me, my lord, that one Mr. Khalis, that the Abdul Khalis, he has collected some amount of money on my behalf. That is the FIR says. Now,
why, whether you moved bail application before the magistrate court?
Yes, it was rejected.
It was, on what ground it was rejected?
Rejection normal, my lord, the nascent stage, my lord.
Whether after perusal of the case diary?
No.
Yeah.
No?
Where is the rejection?
My lord.
Page 27. Lord.
Oh, sorry, my lord, it's page 32, my lord. Page 34, my lord. This is important, my lord. We peruse the case diary, page 34, last paragraph. Peruse the case diary, perusal of the case diary shows that the co-accused person in the instant case implicated accused Rakibul Huda in his involvement in the instant case. That means co-accused has implicated me. The co-accused stated that the so-and-so who have taken initiative to manage the superintendent of police Nagaon to help the other co-accused in this matter. This is my involvement, madam. As per their statement of the co-accused, madam. But as far as the forwarding is concerned, and the FIR is concerned, another my lord, his name is my lord, Abdul Khalis. He has taken money on my behalf. That is the allegation in the FIR. But he not paid to anybody. My lord, kindly see, there is they have implicated, my lord. Where is the case, my lord, of the theft, my lord? Where is the case of theft, my lord? It is only an apprehension that they are.
Perusal of the case diary may be necessary.
Yes.
Your submission is that no offense has been made.
Well, considering the FIR itself, and my case is that what in the case diary that the co-accused only implicated me at this stage, my lord. Therefore, apart from there is nothing in the order sheet also. That the only co-accused has implicated, and what the co-accused has committed offense, my lord. Suppose they are traveling, they were apprehended on suspicion that.
Though from FIR, many things are alleged.
Yes, my lord, but first of all, there has to be a theft. First of all.
Theft does
But
not.
there is no allegation of the theft. Now theft is committed, my lord. Where is the organized crime, my lord? For the offense of organized crime, there has to be previous cases, my lord. That is the requirement of the law. You cannot say that so many people are involved. Then wait, my lord, that anybody can make an allegation that the so-and-so was earlier involved. He was also involved in the organized crime. Not a whisper.
What is the offense?
The offense is the
Section.
organized crime, my lord.
Section
The section or the new section, my lord.
1.
111, my lord. The Nelson number. The
What
now
is-
for that, my lord, the requirement of that, there has to be previous offenses. It's a cognizable offense that there has to be mentioned in the offense itself that these are the person were involved in earlier occasion in a cognizable offense, my lord. That is the requirement of the organized crime, the 111, the explanation 2. There has to be a continuing unlawful activities. And what is continuing unlawful activities has been described very clearly, my lord. There is no mention.
No, it is alleged in the FIR
Yes,
that the
that is what my submission is that
That
anybody can allege that the person were involved in the organized crime. Anybody, my lord.
now
For
whether
that,
materials are there or not.
yes, my lord, there has to be in the material, but the case that it does not show that these persons was involved in the organized crime, or I am involved
No,
in the
I have-
organized crime, or my lord, is only is that the so and so, somebody has implicated me. But whether these persons are also involved in the organized crime.
Yes, whether
That is-
materials are there or
My
not.
lord, for that, my lord, there has to be mentioned in the FIR or in the forwarding report, at least one case that these persons were earlier involved in so and so cases. That is the requirement of the explanation, my lord, the Roman 2.
Yes, for that
There has to be
case-
some mention, my lord.
case
Some-
diary would be
My
necessary.
lord, why is the forwarding, my lord? Why this forwarding is required? Why this FIR is required? They have explained everything. They can get every information because only this is a secret information. They can say that this is an organized crime. Then why, if it is an organized crime, they can register it. Where is that organized crime? Where from they gathered it that these persons shall lordship kindly see the continuing offense means an activity prohibited by law, which is cognizable offense is punishable.
No.
So that means a cognizable offense has to be there. There has to be some material of a cognizable offense in earlier material. Some material they have to implicate that these person there's a cognizable offense has been registered. Only saying that this somebody that's a well that omnibus statement
No,
can be
only
made.
saying may not be enough. But after lodging of the FIR, there may be some progress in the investigation.
Yes, where in my forwarding lordship kindly see. Where is my forwarding lordship kindly? I have been apprehended on 5th. The FIR was lodged on 8/1. And I was after 5 days. What is in the my forwarding, my lord? It says just the replica of the FIR and the ground of arrest now lordship kindly see.
No, this case, I think that perusal of the case diary would be necessary.
My lordship kindly see the grounds of arrest, my lord, in my case, my lord. Lordship can collect the case, call for the case diary report, no problem on that, my lord. I can understand that. But
Yes.
my understanding with a limited knowledge, my lord, that is this is sufficient for the ground of arrest if for an organized crime I have committed? Where is my organized crime, my lord?
Your submission is that
Lordship kindly see arrested accused person, FIR name accused person.
no,
Sufficient material evidence.
let me put query. Your submission is that FIR should itself disclose the earlier of it.
Yes,
earlier-
definitely. When you are registering in a case, registration is not
FIR
just a formality, my lord.
Yes, in the FIR, there is a mention about theft of
Something, but there has to be a
but
cognizable
specific
offense. No
specific details.
In my forwarding also, there's no specific that this person was, or the other person was involved.
There may be in the case diary.
Well, if that is in the
If
case
it is
diary,
not in the case diary, you
If-
may get benefit.
well, why not in the forwarding? What prohibited them to that mentioned when I have been apprehended, my liberty has been taken away. And the liberty of a person has been taken away, and that the lordship kindly know how they have apprehended in the FIR. They said I have been apprehended, whereas I have not been apprehended in the FIR. That means the FIR itself is some fabrication is itself there. Lordship, that the FIR, that means they have incorporated in everything in the FIR. Even my name was incorporated as a apprehended person in the FIR without being apprehension. How they have incorporated that, my lord? This is first time I have seen. That means what? The FIR has been pre-planned manner. It was saying showed that I have also been apprehended. Then where is my apprehension? 8% been apprehended as per the FIR. Where am I, my lord? Am I fled away from the place of occurrence? It's not a case, my lord. they have the, on a secret information, it is an FIR, my lord. It is not an one-line FIR. They got the FIR with a secret information that this person was going to do some crimes, my lord. This is there, but there is no mention about the what offense they have earlier committed, what theft they have committed. Their case is that we have been going on in that particular area to commit an FIR, this person.
No, I have understood. The order of the magistrate also does not specify in detail what is there in the case diary.
Only said that I have been implicated by the
Yes.
co-accused.
Now
Whether I have implicated by
your
the
main plea is that the FIR does not make out a case except the allegation under 111, and for that also specific cases are to be mentioned in the FIR.
Yes, well, that is the
That is your submission.
And when the person was arrested, man, at least in the forwarding report, that expectation is there, so that the magistrate can make out in the forwarding report.
But
that yes.
magistrate has perused the
And
case-
after
case diary.
perusal also, he said that the co-accused has implicated me. The co-accused, there has to be some organized crime for
Yes.
that reason.
How he has implicated you, that
I
we
don't know,
don't
the
know.
neither magistrate knows, my lord, the FIR does not.
Therefore, perusal of case
The
diary.
forwarding does, the report
We are
does not say,
we
my
are
lord.
fixing a short date. Short,
Forwarding report also doesn't say, my lord. I have a doubt, my lord, whether the case that will come, even the lordship is fixing a
no,
short date, my lord.
it is from Nagaon.
Lordship.
Sharma, when can you bring it?
Lordship, 19.
19.
Okay. Short date, it's a regular date, my lord, 19th. It's a short date, my lord.
Mr. Sir, regular date, Lordship.
Huh?
No.
It's not a short date, Lordship.
No, make it shorter.
Okay, make it shorter. Then Lordship, 16.
Next week, my lord.
16.
Next Friday.
Okay. Obliged.
Thank you. In item number 31, heard Mr. A.M. Bora, London Senior Counsel, requested by Mr. V.H. Chaudhary,
52 or 52.
London Counsel for the petitioner. Also heard Mr. V. Sharma, London Additional Public Prosecutor. Considering the nature of allegations leveled in the FIR, and after hearing London Counsel for the Senior Counsel for the petitioner, this court is of considered opinion that perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the same, fixing 16 August for the case diary.
My lord,
In 50 and 52 same orders, counsel, name of the counsel may be different and submission part will be given.
obliged.
Highly object.
Well, my lord, it is clearly stated that first the land grabbing special tribunal will decide the civil liability, and afterward,
First civil liability,
and then it will go.
but
for-
you made
My lord, yes,
submissions
yes.
in a
Then it will decide criminal liability. Therefore, my lord, on same set of facts, two proceeding is impermissible. Second thing is a case of also, my lord, that conflict of decision, my lord. And third ground is that, my is a case of other double jeopardy, my lord.
heard Mr. S. Samaria, learned counsel for the petitioner. This application under section. What is 438? (438) of BNSS. What is the provision?
My lord,
What is 438? Which
it's
you,
the original part, my lord.
revision? (438) read with section 442 of BNSS. You have not filed this petition under the,
My lord, that now is a very serious situation that if suppose the proceeding earlier drawn out in earlier law, my lord, but normally it has been accepted, my lord, by the registry.
442 of the Bharatian for setting aside and quashing of impugn order dated 22/5/2024 passed in CR case number 71C/2020-24 by the Court of London, Subdivisional Judicial Magistrate Sadar, whereby the court took cognizance land grabbing. By this order, the cognizance under Land Grabbing Act was taken up.
My lord, page 51. 11/3/2024.
Which order you are impugning?
SLing, my lord, page 54, I'm SLing. That pertain to complaint case. And land grabbing case pertain to, my lord, order dated.
You are
11
not challenging land grabbing order.
No, I'm challenging CR case because land grabbing case is a special law which is already initiated, cognized, taken care of.
Okay. To cognizance under section 143/342/352/379/447/506/34 of the Indian Penal Code against the petitioner. Learned counsel for the petitioner has submitted that on same set of facts, another case, that is
Page 51. LA case number.
That is LA case number 4/2024 was filed, wherein the court has issued notices to the respondents. So, issue notice to the respondent. State is not, you have not made state as a respondent. This is a
State
complaint case.
Yes,
Okay.
complaint case, no, private party.
Respondent. The appellant, the petitioner shall take steps for issuance of notice to respondent by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 12th of September 2024. Call for the scanned copy of case record of CR case number 71C/2024 from the Court of London Subdivisional Judicial Magistrate Sadar Tinisukia. Stop. Considering the averments made by the petitioner in his petition, the further proceeding of CR case number 71C/2024 shall remain suspended till next returnable date. List accordingly.
Deeply.
ये तो correct है.
May it please allow.
Item number.
My lord, initially this complaint was filed under old code. Then, my lord, an objection was raised, but having regard to, my lord, urgency as far as we are concerned, so we took leave from the honorable court to withdraw and file it under BNSS, keeping the issue open. Now, what had happened, my lord, the petitioner number one, petitioners, they are all, my lord, directors and officers and directors, all directors of, my lord, an USB private limited company, which amongst others produces, my lord, manufactures a drug called New Vesca. It is being manufactured at a plant in Himachal Pradesh. And normally, my lord, this is used in treatment of diabetic neuropathy.
Diabetic.
Yes, diabetic neuropathy. Now, my lord, the allegation is that the drug is not of standard quality. So that is how, my lord, a complaint has been filed. My lord, if your lordship would kindly permit me to place the complaint, if your lordship would kindly come to page 57.
Yes.
This whole thing is, my lord, void ab initio. Please come to para 23 at page 57. That the complainant begs to state that on 10/10/23, the complainant's office has requested the Deputy Solicitor General India Guwahati
Who
High
is the
Court.
complainant?
Complainant is the, my lord, drug inspector,
Oh, drug inspector.
Union of India, yes. Complainant begs to state that on 10/10/23, the complainant office has requested the Deputy Solicitor General India Guwahati High Court, while file number dated so and so, to nominate a central government council to launch prosecution, file complaint case before the learned court of Chief Judicial Magistrate Guwahati for manufacture or for sale or distribution of subject batch of drug falling under category of not of standard quality drugs under section so and so of the Act. My lord, if your lordship recollects, under section 24 of the old code, and section 18 of the present code.
24 of the 6 CRPC.
Yes. Please come to section 24. It goes to the root of the matter in my humble submission. For every high court, the central government or the state government shall, after consultation with the high court, appoint a public prosecutor and may also appoint one or more additional public prosecutor for conducting in such court any prosecution, etc., etc., etc. So central government standing council is not a, my lord, prosecutor. Let us be very clear about it. So that is the first infirmity. So prosecution can be launched either by public prosecutor or by additional public prosecutor.
Okay.
Now, my lord will kindly come to, so that is my first point. Second, lordship will kindly come to page number 75. Page 75. Now, this is the, my lord, sanction order. It is given by Government of India. Have the lordships got it?
Yes.
In this connection, approval of the controlling authority is hereby conveyed to launch prosecution against the concerned firm person for violation of the provisions of the Drugs and Cosmetics Acts and Rule. But where is the application of mine? Why a person sitting in America has been, someone has been issued against him? Two of the directors are residing in America. No inquiry. Can, my lord, sanction order be of such type? My lord, I will place one judgment of the Supreme Court on this point. Sanction. My lord, may kindly have this. My lord, referring to 1997 7 SCC 62, para 14. The sanction for prosecution given in the present case appears prima facie to suffer.
Just a minute.
What
What is the offense involved in this case?
Offense is, my lord, that this particular drug is not of standard quality. And, my lord, the process has been issued under section 27 capital D. There is no such provision in the statute book.
What is 27D?
Kindly see my lord, Drugs and Cosmetics Act. Drugs and Cosmetics. These are all
Whoa.
mechanical exercise of power. There
27D is not there.
is no 27D in this statute. The total non-application of mine. My lord will kindly come to the impugn order at page 43. My lord, when you are setting criminal law in motion, especially when the alleged accused are outside the court jurisdiction.
Page 43.
Yes, page 43. Now, my lord, this whole big paragraph, this is about who is the complainant and who all are the accused. Then one line. Peruse the complaint petition along with the annexures. I find prima facie case against the accused persons. Sri so and so. Number one is the company.
27D is not there in the statute book. Then
Prasant Kumar so and so accordingly cognizance offense under
is there any amendment?
No, my lord. Huh? Oh, this is the latest book, my lord.
Drugs and Cosmetic Act.
To the best of our knowledge, we have checked, my lord. There is no such amendment, no nothing.
And where is the complaint?
My lord.
Complaint filed by the
Page 44.
drug inspector.
Yes.
What section it refers in that?
Yes, yes. That, my lord, will kindly come to page 57. I have already read that paragraph. And the complaint is under 27A.
27A.
A. D, small.
This small d.
Complaint for offences under section 16(1)A, 18(1)I, and 18(B, read with section 34 of the Drugs Act. Well, section 34 has been added to bring in the directors. Lordship knows there is no vicarious liability of the directors. Unless directors, as far as directors are concerned, some role can be attributed in the wrongdoing. Well, there is no scope of roping in the directors. My lord, here is a case in my humble submission. First, my lord, the very, process of seeking prosecution sanction is wrong. Secondly, Deputy Solicitor General is not competent. Thirdly, my lord, there was no inquiry.
Who has to grant prosecution sanction? Union.
We are not, disputing the authority of that authority. Question is the manner in which it has been given. Can it be given like that, my lord? I think there has to be some application of mine because the people are, all these are directors, my lord. And lordship knows under section 34(1), if you want to rope in the directors in terms of the Supreme Court's order, then the order has to specify why so-and-so is being, roped in as an accused. There must be some allegation in the complaint. There is nothing. I can read the whole complaint, my lord. There is no allegation against any of the directors.
Who is appearing for Union of India?
CGSC, my lord. Lordship will serve them copies, my lord. We have served copies also.
You have served.
Yes, sir. Without my lord, service office will not accept.
Their names are not. Their names are shown or not?
Yes.
Names are shown.
Deputy SGI. Let them appear and my lord satisfy why they have done it, my lord. Then we'll see, my lord.
Heard Mr. K. N. Chaudhary, learned senior counsel assisted by Mr. H.
A. Das.
Yes, A. Das, learned counsel for the applicant petitioner. No one has appeared for. No, for state. Also heard Mr. State is also a party.
State is also a party.
Also heard Mr. P. Bhattakur. learned counsel, additional public prosecutor. No one has appeared for Union of India. Though learned senior counsel has submitted that the counsel for the Union of India has been provided with has been notified regarding this case and provided with the copy of application. This application under section 528 of BNSS, 2023 has been filed by the petitioners 1, 2, 3, 4, 5, 6, and 7, impugning the order dated 1/2/2024 passed by learned additional Chief Judicial Magistrate, Kamrup Metro, whereby cognizance of offence under section 27 capital D of the Drugs and Cosmetic Act, 1940 has been taken by the concerned court and processes were issued to the present petitioners. Learned counsel for the petitioner has submitted that where is the complaint petition?
Page 44, my lord.
That the Union of India through the drugs inspector of the Assistant Drug Controller within bracket India, Central Drugs Standard Control Organization, Sub-Zone Guwahati, has filed a complaint case against the present petitioners, against the company is also a party.
Yes, my lord, number.
Against the petitioner number 1, against the present petitioners, as well as Messrs. USV Private Limited, of which the petitioners are directors. Of which the
One is MD, others are directors. Director,
learned counsel for the petitioner has submitted that for initiating prosecution for violation of any provision of Drugs and Cosmetic Act, 1940, as well as rules of 1945. Prosecution sanction has to be obtained. And in the instant case, how the role of standing, which you have referred to.
Page 57, my lord. Para 23.
Learned senior counsel for the petitioners has submitted that in the instant case, instead of public prosecutor, the complainant's office had made a request to the Office of Deputy Solicitor General of India for deputing a central government standing counsel to launch prosecution and to file complaint before the Court of Learned Chief Judicial Magistrate, which according to learned senior counsel is violative of the provision of section 24 of the
CRPC.
Code of Civil Procedure, 1973. Learned senior counsel has also submitted that bare perusal of the
Page
le-
75.
letter by which prosecution sanction was accorded would show that there was there was no indication that there was any application of mine before according prosecution sanction in this case. Learned counsel for the petitioner has also submitted that where is the impugn order?
Page 43, my lord.
That on perusal of the impugn order dated
1/2/24.
1/2/24, it is apparent that the cognizance by the impugn order, the cognizance of offense was taken against ten accused persons, including the above named petitioners, under section 27D of the Drugs and Cosmetic Act 1940. However, there is no such provision in the statute as mentioned in the impugn order. Stop. I have considered the submissions made by learned counsel for the learned senior counsel for the petitioner, as well as peruse the materials on record. Apparently, it appears that the impugn order appears to be flawed to the extent that cognizance of offense against the present petitioner was taken under section 27 capital D of the Drugs and Cosmetic Act, when no such statutory provision exists in the statute books as on date. In view of the above, let the notices be issued to the respondents. As learned public prosecutor has appeared for the
Respondent number
learned
3.
additional public prosecutor has appeared for respondent number 3, and notices were already issued to served on Deputy Solicitor General of India for respondent number 1. No formal notice need to be issued to them. Who will appear for number 2? Notice will
They only, my lord, central government. AP will have to apply. AP for the central government. Or we'll serve
whether
them copy, we'll serve another copy, my lord.
the petitioner is directed to
Or
serve
we
the
can take steps by registered post as your lordship.
petitioner is directed to take steps for issuance of notice on respondent number 1 and 2 by registered post with AD as well as by usual mode within 3 days from the date of this order. Stop. The notices are returnable on 20th of September 2024. Further, in view of the submissions made by learned senior counsel for the petitioner, as discussed herein above, the further proceeding of which case? CR case number 614/2023 shall remain stayed till further orders.
Deeply.
Regular bail application, my lord, was arrested on 9/8/2024, my lord. But you'll find the FIR in the page number 8 onwards, my lord. My allegation is Tokaiti of Gondal ornaments and kill acquisition.
Case diary would be required.
That's also been covered. In the meantime, my lord, may I have it, my lord? The co-accused already filed a bail application. And CD has already been called, my lord. It is
When?
fixed on 13/8.
13/8.
13/8 bail application number
Okay.
2247/2024.
2247.
2247. 24.
Heard Mr. S. Bora, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. Let the case diary be called for. Learned counsel for the petitioner submits that in a connected case arising out of the same police station case, a co-accused has preferred a bail application in which case diary has been called and which is fixed on 13/8/2024. Hence, this case may also be listed along with the same. Stop. Call for the case diary. No, stop. Let this case be listed on 13/8/2024 along with bail application number 2247/24.
Okay.
Item number 50 of code number 24. My lord, in this case, my lord. Kindly see, my lord, the page 46. my lord. Page 46, my lord.
Scan copy has arrived.
My lord, I have pursued in the section, my lord. It is yesterday's scan copy received in section, my lord.
But it is not.
So,
Thank-
my lord, my submission may be fixed on 12 with records. Fixed on 12 with records, my lord.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 7/8/2024, it appears that scan copy of the trial court record which was called for has not been received. Stop. However, learned counsel for the petitioner submits that he has been informed that the scan copy of the case record of the trial court record has been received by the registry today only,
Yesterday.
yesterday. In view of above, let this matter be listed again on 12/8/2024 along with the scan copy of the case record which was requisitioned from the trial court.
Item number 32 of code number 14.
Here, charge sheet has been laid down, Lordship.
Charge sheet file,
Yes, Lordship.
what is the offense?
Lordship.
Your lordship, 87 of BNS, your lordship, already 30 days. Behind the
What
bar.
is 87?
87, your lordship, kidnapping and abducting of women, your
You
lordship.
go
from
before the trial court.
Your lordship, already 30 days, your lordship.
Heard Mr. S. Paul, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has already been laid, bearing charge sheet number
228/24 dated 31/7/24.
Stop. In view of the laying of the charge sheet in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file a regular bail application before the said court, if so advised.
Trial court may consider, your lordship, if possible.
Trial court will consider.
Also, your lordship, they were in relationship. And the girl is also major, your lordship. On the last date also, your lordship was about to grant bail without going through the CD, but only because of section 87, your lordship.
Now, go to the trial court, convince the trial court.
Oblige, your lordship.
Here, Lordship, CD has not been received.
CD has not been received.
Yes, Lordship.
Heard Miss A. Payang, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
Lordship, maybe on 18.
18 is
Sunday.
Sunday, 19.
19.
On 19.
Item 44.
In this case, Lordship,
also
scan
Lordship.
and share call Lordship. Research it.
Item
LCR has
not been issued probably.
not arrived. Heard Mr.
Discussion.
S.K. Sinha, learned counsel for the petitioner. It appears from the office note dated 7/8/2024 that the scanned copy of the case record, which was called for in this case, has not yet arrived. Stop. Registry to issue reminder for requisitioning the scanned copy. Place this matter again on 16/8. 16/8.
Let him know 19 Lords.
19/8 for case diary.
In the meantime, Lordship, I may be allowed to correct the cost item.
Most. You file a interlocutory
439.
application.
It should be under 483 of the BNFS.
Learned counsel for the petitioner has prayed for allowing the petitioner to amending the first title of this application. The prayer is allowed. The petitioner shall take necessary steps in pursuant to notification number 79 issued by this registry on 19/6/2023.
Obliged.
Item 54 was uploaded in code number 14.
Lordship, item 54 and 41 arising out of same FIR, my lord. 41 is AV and 54 is BA.
So first we will take up BA, then we'll take up AB. Who is for 41, different set of lawyers? For 41, who is appearing?
To me.
Yes, I'm.
For both the cases, you are appearing. Okay. Then 54, make your submissions. What is this?
483 application of Lordship, and here in this case, Lordship, the FIR will find page number, Lordship, 11.
His diary is available.
Yes, yes, there
And
is.
Lordship, the petitioner is a boatsman, Lordship, and they have the boat in
No,
the
no, no.
river set.
54 first.
54 first.
Lordship, 54. Lordship. And page number 14, Lordship, and briefly, Lordship, and there is, may I read the contents of the FIR, Lordship?
Yes.
14. The brief fact of the case is that on 24/5/2024, complainant Rafiq Ali, son of Hazrat Ali, of Gheragla, part number 2, and Gheragla, Lordship, and part number 1, and so and so. And during the laws and Dhubri, laws and FIR, and this page of the this PS to the effect that today on 24/5/2024 at about 12:50 AM, some person came to his house and directed him from the outside of his house and opened the door, and they call him that they come from Gauripur police station and they have to search this house, then open the door. After opening the door, as soon as wearing combat uniform, 6 persons and 1 in civil dress, and total 7 numbers of person enter into his house and equipped with weapons. 7 numbers persons search 4 rooms of their house and without taking in the witnesses and tell him that he runs the business of money and money lending and fake currency, and threatening or intimidation, Lordship. And the said so and so, Lordship. In connection with this, Lordship, there are 7 persons enter into his house, Lordship, and they demanded him. The informant is doing the money lending business and fake currency, Lordship. But they wearing the police uniform, Lordship. But the present petitioner is a boatsman, Lordship, and he is engaged by one, Lordship. And
What is the name? Present petitioners.
Lordship, and Mofizul Sheikh. And kindly come to page number 19, Lordship, annexure 3. Lordship, and here one the Sofiur Rahman Lordship, and he is the owner of the Parghat Lordship. And they are the daily wages laborer Lordship, 2-person Lordship, boatsman. And one is arrested, and one Mufizul Sheikh is arrested, another 41 is heavy Lordship. And he is engaged by him Lordship and as a boatsman Lordship and the regular basis Lordship, and the Parghat is opening for 24 hours. And that is the government Parghat Lordship. And so, my lord, some police person went to the Parghat and they crossed the river, and on fair Lordship, and if there is any happened, and they are the illiterate person, and thumb impression is their Lordship. And they have crossed the river, and subsequently they went to the house of the informant, and if they have loaded, and that is up to them Lordship. But he is a daily wages laborer Lordship. We have no any involvement at all Lordship. And on fair Lordship, police, and they have, there is nothing to say Lordship, that because they were wearing the police uniform Lordship. So, my lord, otherwise I am very clearly mentioned in my petition. And
When were you arrested?
Lordship, I have been arrested Lordship on 21/7, and as on today 27 Lordship, and as on today Lordship 21 days, 21 days Lordship. But other person was arrested Lordship, and those who are involved in this offense Lordship, and already granted by the learned court session judge Lordship. And they are namely Lordship Azad Ali Khan, Anar Ali, Ilyas so-and-so, and another is Lordship Razzaq Alam, and 2%, no? Razzaq Alam. And another is Lordship Ibrahim Ali Lordship. And they were immediate after lodging the FIR Lordship, they have been arrested Lordship, and all the some ornaments and some, even the dress has been recovered from one Hazrat Ali Lordship, and he is already been arrested Lordship. But nothing has.
Whether Hazrat Ali is on bail or
no, he is in custody now, judicial custody.
what is the allegation against you?
Lordship, perhaps Lordship, as per the police Lordship arrested me Lordship. I don't know. Actually, I have nothing. No, I have not involvement at all.
No, what is there in the forwarding against you? Forwarding report. On what ground you were arrested?
Forwarding Lordship, these are the common language of the police Lordship, and ground of arrest may I read page number 18.
Your name is Mufizul Sheikh.
Page number 18.
You helped the dacoits.
17. And the ground of arrest may I read Lordship. Previously arrested accused person Shah Alam Mullah Nur Nabi Ahmed Anwar Hussain.
Next please.
18. And
During interrogation.
During interrogation, arrested accused person has been admitted his involvement in the commission of the crime. Lordship. This is the allegation only by the co-accused Lordship.
Ground.
And during the interrogation, arrested accused person is not fully cooperated with the investigation, for which their thorough interrogation is urgently required to unearth and the actual fact of his involvement of this case, to recover the engine run boat which he uses and for the documents, and to identify the hidden place of the fugitive accused persons, Parek Ali, Saidul, Shahjamal Sheikh, and Rasul Haq, Rufsan Ali, and Shurat Jamal, and these are the Lordship name is mentioned. And let the police find out many important facts which will help the busted the gang of the Lordship. My name is not here, Lordship.
Yes.
Yes, my lord, some of the arrested accused, my lord, their statement recorded, and my lord, they says that, my lord, they help other persons, my lord, those actual dockets, my lord, and that is the main allegation against this 2-person, my lord. And other all facts, my lord, here narrated by the co-accused, my lord, they sold out those gold ornament for 1,92,000 rupees to a person. And this present statement of Barak Ali, he received his share of 12,000. That's all.
Know whether this custodial detention is necessary.
Custodial interrogation, he has, my lord, arrested and thoroughly interrogated. But so far, my lord, PRS bail is concerned, my lord, I have objection, my lord.
heard Mr. F. Hawk, learned counsel for the petitioner, also heard Mr. B. Gogoi, learned additional public prosecutor. This application under section 483 of the PNSS 2023 has been filed by the petitioner, namely Mofizul Haq, who has been detained behind the bars since 21/7/2024, within bracket for last 21 days, in connection with Gauripur PS case number 139/2024 under section 419/395/399/412/120B of the Indian Penal Code. The gist of accusation in this case is that on 24/5/2024, one Rafiq, what is the name of the one Rafiq Ali had lodged an FIR that on that day at about 12:50 a.m., 7 unknown persons carrying arms and wearing police uniform within bracket 6. One of them was in civil dress, bracket close. Came to the residence of the first informant and identified themselves as police.
Lordship.
Police and threatened the first informant. And thereafter, they looted golden ornament valued about 5 lakhs, as well as cash of rupees 10,000 and some other articles. Stop. On the basis of the said FIR, the Gauripur PS case number 139/2024 was registered. Learned counsel for the petitioner has submitted that the petitioner is an innocent person and is a boatman by profession, and is where you work.
Lordship, in the Pargate, Lordship, under the Supreme Roman Lordship, as a boatsman.
And
Para number 4, I have mentioned, Lordship.
stop. It is also submitted by learned counsel for the petitioner that the petitioner has been detained behind the bars for last 21 days. However, in the meanwhile, 4 of the co-accused who were arrested in connection with this case have already been released by the Court of Learned Session. Which court this is? Which court released you? Learned Additional Session Judge Dhubri. Stop. Learned counsel for the petitioner has submitted that the co-accused Anar Ali Khan and Anar Ali, Razak Ali and Ibrahim Ali are already released on bail. And considering the period of detention undergone, he may be also allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Gauripur PS case number 139/2024 and has submitted that the present petitioner used to assist the other accused in commission of dacoity by assisting them to cross the Brahmaputra by the engine run boat which he used to operate. However, he submits that the petitioner has been thoroughly interrogated and his statement are also recorded by the investigating officer. Stop. I have considered the submissions made by learned counsel for both the sides. Considering the submissions made by learned counsel for the parties, as well as considering the fact that the investigation has fairly progressed and also considering the fact that some of the co-accused are in the meanwhile already allowed to be released on bail, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of investigation in Gauripur PS case number 139/2024. In view of above, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of Chief Judicial Magistrate Dhubri with following conditions. Condition number 1 and 2. There are two conditions. Take from the anticipatory bail is, what are the materials against him?
Metal, he is also, my lord, boatman, my lord. Similarly situated with that previous, my lord, that petitioner, but here anticipatory bail only.
No, against him is there accusation?
Accusation, my lord, that he helped the other main accused, my lord. But here one statement of other arrested accused said that, my lord, she was also with them, my lord, that I do not know, my lord. Hey, mote moi logor bondhu so and so, he is also named, my lord. Mili so and so tinikhon motorcycle aru Nur Nabi Ahmed so and so dukhon motorcycle soho jao aru BSF Husak kot Hozrat Ali logot loi jai aru.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 482 of the BNSS 2023 has been filed by the petitioner, namely Shahidur. Two petitioners are there.
Yep. Two already arrested, number 2.
Petitioner Shahidur Sheikh, who is apprehending his arrest in connection with Gauripur PS case number 139/2024 under section 419/395/120B/399/412 of the Indian Penal Code. The gist of accusation, same as the earlier case, gist of accusation, copy called. Learned counsel for the petitioner has submitted that the petitioner is a boatman and is not involved in the offense alleged in the FIR. Stop. He also submits that the petitioner is ready to cooperate in the investigation. stop. However, then the additional public prosecutor who has produced the case diary of Gauripur PS case number 139/2024 has submitted that there are materials in the case diary indicating that the petitioner assisted the other co-accused persons in committing the dacoity which has been alleged in the FIR. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the case diary. Considering the materials available on record against the present petitioner, this court is of considered opinion that this is not a fit case for grant of anticipatory bail under section 482 of BNSS, 2023 to the above named petitioner. Hence, the prayer for anticipatory bail is rejected.
What observation kindly, my lordship, and I may be surrendered before the learned court below, lordship. I will appear, lordship, to the court below surrender.
No, your option is there. You may yourself surrender. I'll not make any such observation. You cooperate.
The honorable can direct, lordship, I will go, I will be
The
appearing.
petitioner is directed to cooperate in the with the investigation.
Published.
Item number 16 of court number 24. Item 16 court number 24.
None appears for the appellant, none appears for the petitioner on call. Let this matter be listed again on 13/8/2024.
Item number 36 of court number 48.
My lord, in this case, my lord, case diary received, but later on in this case, my lord, 302 added, my lord. But my lord, PM report, my lord, CD needs to be updated, my lord. PM report is not available in the case diary.
302.
302 added, my lord.
What is your case?
Lordship, FIR is page number 9.
Is there any
Yes, my lord, one dying declaration is also available in the case.
implicating?
Yes, implicating the present accused.
Then we'll reject the application. Then we'll.
Yes, this is the dying declaration.
No, he has the deceased has implicated.
Yes, implicated.
Then you don't
my
have a
lord,
case.
I again state that, my lord, only last portion, my lord, vital portion, my lord, while in presence of the doctor, my lord, I again state that it was intentional attempt made by Razul and his mother. Hence, I hold them responsible for my condition, my lord.
Who are petitioners?
Petitioner is Razul Ali, petitioner number 1, and his mother, my lord,
Saira Begum.
Saira Bai.
And against Papu Ali?
Against Papu Ali, Sahaj Ali,
Son of
she has not implicated in her dying declaration.
Whether any other,
Yes, my lord, other statements, my lord, regarding
whether any implicating materials are there against Sahaj,
uh,
Papu Ali and Sahajul Ali?
yes, my lord, because from the statement of the some of the witnesses stated that after marriage, my lord, the family members of the accused persons tortured the deceased victim. My lord.
Deceased is the
This
lady.
is the wife of petitioner number 1. My lord.
Okay, then we are granting anticipatory bail to 3 and 4.
3 and 4 may be wrong, but
And
1 and 2, my lord,
1
there
and
is,
2, we are
specific material against.
rejecting the
Yes.
petition. Heard Miss, what is your name?
J.
J?
Begum.
Heard Miss J. Begum, learned counsel for the petitioners. Also heard Mr.
P. Bhattakur.
P. Bhattakur, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Syed Rajul Ali, number 1, number 2, Sayara Begum, number 3, Papu Ali, number 4, Shahjul Ali, who are apprehending their arrest in connection with Goreshwar PS case number 30/2024 under section 307/34 of the Indian Penal Code. The gist of accusation in this case is that on 19/5/2024, one Muhammad Tafzul Ali had lodged an FIR against the above named petitioners before the officer in charge of Goreshwar Police Station, inter alia, alleging that
This is expired on my lord 23/5/24.
that Rajul Ali married one Tarikan Bibi about 5 years ago, and after that she was subjected to cruelty by the above named petitioners, and it is also alleged that the petitioners assaulted her and set her on fire by using petrol, and the victim woman was struggling for life when the FIR was lodged. Stop. Learned counsel for the petitioner has submitted that the allegations made against the above named petitioners are not true and they are innocent. It is also submitted that they are ready to cooperate in the investigation if allowed to go on bail. On the other hand, learned additional public prosecutor Mr. P. Bodhakur has produced the case diary of Goreshwar PS case number 30/2024 and has submitted that in the meanwhile the victim Muslim Tarikan Bibi has succumbed to her injury on
23/5/24.
23/5/2024 and section 302 has been added.
Added.
Section 302 of the Indian Penal Code has been added to this case. He has also submitted that before dying, the victim had made a dying declaration wherein she had categorically implicated the petitioner number 1, Syed Rajul Ali, who was her husband, as well as petitioner number 2, Sayara Begum, who was her mother-in-law. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Goreshwar PS case number 30/2024. Considering the fact that in the dying declaration made by the victim girl, she has categorically made implicating statement against the petitioner number 1 and petitioner number 2, namely Syed Rajul Ali and Sayara Begum respectively. Hence, this court is of considered opinion that both the above named petitioners are not entitled to get a favorable order under section 482 of the BNSS 2024. Therefore, the prayer for their anticipatory bail is rejected. However, as regards the other accused persons, other petitioners, namely Papu Ali and Shahjul Ali, considering the materials available on record, this court is of opinion that their custodial detention may not be necessary for fair completion of the investigation if they cooperate in the investigation. Hence, the petitioners, namely Papu Ali and Shahjul Ali, are directed to appear before the investigating officer of Goreshar PS case number 30/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Goreshar PS case number 30/2024, the above named petitioner shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to satisfaction of the arresting authority with following conditions. Condition number 1 and 2. With above observation, this anticipatory bail application is hereby disposed of.
Nice.
I beg your pardon, Lordship. Item number 16 of this court, Lordship. We are just called, Lordship. It has been charged sheeted, Lordship.
16.
Of this court, Lordship.
16, what we have done. On 13, we will pass orders.
Item 47.
My lord, this is a quoted bail application, my lord. Okay, is at page 9, my lord.
What is the offense?
Offense it is, my lord, as per allegation, my lord, the FIR was lodged after a month of offense, my lord. And it was lodged on 31/5/2024. And it was, incident was occurred on, allegedly on 2nd of May, 2024.
302 is there.
My lord,
302.
302, but.
Who
there-
died?
Lord,
Who died?
yes, the brother of the informant died,
Brother.
brother. And the FIR is.
Laws on 2/6, incident 2/5, FIR laws on 2/6/24.
No,
Next day itself.
no.
Brother of the informant died. Who are you?
Yes, I am, actually, I am nowhere correctly because I am not their family members. And FIR is mainly, the allegation is against the wife of the deceased. The brother has alleged that while his brother was alive, then the relation with his wife, it was not good. And that is why ultimately it was compelled to him that to commit a suicide.
But why are you apprehending?
Yes, my apprehension is that my name is there in the FIR. And
How? Therefore, I am asking, what is the allegation against you?
Yes, my lord, allegation is that brother has alleged that I had some extramarital affair with the wife of the
Deceased. Wife of the deceased.
wife of the deceased, and while he was alive, this was when he was alive. Then during altercation, I threatened him that I have some cases and I am not scared of any committing any. I am not scared of killing anybody. So that is the allegation, my lord. May I read the FIR, my lord?
No, I have understood. No.
My lord, regarding that, I'd like to clear one thing, my lord, because incident occurred on 2/5/24. It is not correct that FIR laws after 1 month. My lord, on 2/6/24 FIR registered, my lord. 2/6/24.
No. 2/6/24 means it was allegation was that on 2/5/2024 the offense was occurred.
Sorry,
The body of the offense is clear, my lord.
FIR was lodged on 31/5.
Yes, but the occurrence it was on 2nd of May.
Sorry, my lord, he is right.
Now,
Well,
what you
here
have
I
case diary?
Yes, case diary received. my lord.
What are the material
Yes,
against?
my lord, postmortem report received. Postmortem report is not conclusive regarding cause of death. Thereafter,
How he died?
Yes, my lord.
How he died?
Yes, my lord. This is now, my lord, FSL report received, my lord. As per FSL report,
because there is also allegation because the deceased person consumes some poison, my lord. And regarding that, my lord, the FSL report states that no poison and its metabolites were detected in exhibit number so and so. So there was no poison detected, my lord. And next, my lord, regarding cause of death, asphyxia as a result of antemortem hanging. But my lord,
So it was death by hanging.
hanging. And next, my lord, injuries present in the chest were antemortem and caused by blunt force impact. So some injuries was also there, my lord. And regarding the present accused persons, my lord, already the present accused persons was appeared because there are some 164 statement and 161 statement of the witnesses, my lord. Those who are the brothers of the, my lord, deceased person, my lord. And they suspect one pen drive is also there in the case diary because they suspect that, my lord, the present petitioner has some illicit relationship with the petitioner number of item number 38. And because of that, my lord, they are responsible for causing death of the present, that is their, my lord, statement.
Suspicion.
Suspicion, my lord.
So he's assuming that he had an
Yes, but
extramarital
now from the
materials, what materials are there against?
materials, my lord, regarding that now only from the forensic report and FSL report, it seems that some injury marks is there. But regarding that injury, my lord, who has caused that injury, my lord, how?
Any evidence is there?
That, my lord, that regarding that injury marks, there is no such evidence in the, but till now in the case, very much. Otherwise, 164 statement, because of the illicit relationship between the both the petitioners, my lord, the brothers of the deceased person suspect that these persons are involved because of who is, my lord, they are the person responsible for who is now the brother of the
No,
deceased
is
person.
this a case of suicide or?
Now, my lord, from the report of the FSL report, it is specifically stated that asphyxia is a result of hanging, my lord. That is the report of the FSL. Your lordship may kindly peruse the report. So because some injury marks is also there, so that part needs to be, my lord, needs further investigation, my lord.
Mr. What is your name?
PK Das.
However, my lord, it cannot be said that, my lord.
My only limited
because-
prayer is that it was only over phone. The other brother has informed, that brother has not lost the affair. Other brother has lost the affair. And it was also 1 month back incident. And my lord, whatever the injuries, my lord, that was, I am not concerned about because I am not their family members. I was not there on the day of occurrence, my lord.
Further investigation will require. Now, at present, my lord, they are strong suspect, both the petitioners, my lord.
And the allegation is
Who
also
are,
my lord, on
yes, who
suspicion.
may be, my lord, responsible for causing those injuries.
No, but since 2nd of May,
Yes,
my lord.
now it is now we are on 9th of August.
9th of August.
The police could not collect anything apart from suspicion. It
Yes.
has not progressed beyond suspicion.
That's
Then
true.
they may not be arrested. Let them cooperate. Let him cooperate.
Only there are some witnesses of 164 of the brothers' family.
That
members.
is only that is also on suspicion.
Suspicion.
Because of the extramarital
Yes.
affairs.
Suspicion is there, my lord.
Assuming that extramarital affair is there,
There is.
but evidence has to be there regarding 302 also.
Yes.
Heard. Let him appear before the IO
Yes, ma'am.
and cooperate in the investigation. Heard Mr.
PK Das, my lord.
P.K. Das, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Farid Ahmed, who is apprehending his arrest in connection with Gitanagar PS case number 123/2024 under section 120B/302 of the Indian Penal Code. What has happened to the wife? Whether she is also arrested?
No, man. Anticipatory bill, man. Her statement is also there in the case diary, man.
One more petition is there.
Yes, man. Item number 38, man.
Next item. apprehending his arrest in connection with Gitanagar PS case number so and so under section so and so. Stop. The gist of accusation in this case is that on 31/5/2024, one Chandrakanta Burman had lodged an information before the officer in charge of Gitanagar police station, inter alia, alleging that on 2/5/2024, the niece of the first informant informed him over telephone that the younger brother of the first informant, namely Khoghen Burman, had eaten something and has passed away. Later on, he was informed by the niece that the younger brother of the informant had committed suicide by hanging himself. It is also alleged in the FIR that the wife of the deceased, Khoghen Burman, treated the deceased with cruelty and was having an extramarital affairs with one Farid Ahmed, within bracket present petitioner. And therefore the informant suspects the involvement of the said persons in the death of his brother and has alleged that the death of his brother is not a suicide but a pre-planned murder. Stop. On learned counsel for the petitioner has submitted that the petitioner is not a family member of the deceased, and the allegations made against him in the FIR are not true, and he is innocent and in no way involved in the offense alleged in the FIR. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Gitanagar PS case number 123/2024 and has submitted that the FSL report of the examination of viscera of the deceased person shows no poison therein. It is also submitted that the postmortem report shows that death of the deceased Khoghen Burman is due to asphyxia due to hanging.
Yes.
Stop. However, learned additional public prosecutor has submitted that the witnesses whose statements are recorded under section 161 of CRPC have stated that there was an extramarital relationship between the present petitioner and the wife of the deceased, and they suspected that they may be involved in the in the death of the deceased person.
And my lord, one audio recording was also submitted, my lord, pen drive of that audio recording between the deceased person and informants and brother, my lord. That, my lord, the
Deceased and informant's brother.
brother, my lord. Informant's brother.
Informant's brother is the deceased.
Yes, my lord. That before
before
1 month before that, my lord.
Between deceased and whom?
Deceased and his brother, my lord. One, my lord, Nobin Burman, my lord.
Okay, what is the
Regarding
content?
that audio, he talks about that cruelty he suffered because of his wife and the illicit relationship between both the petitioners.
Learned counsel for the learned additional public prosecutor has also submitted that there is also material in form of a recorded conversation between the deceased and one of his brother, namely Nabin Burman,
Yes, sir.
which indicates that the deceased reported his brother that he was cruelly treated. He was subjected to mental cruelty due to the extramarital relationship between his wife and the present petitioner. He has named.
Yes, my lord. And he also, my lord, stated that, my lord, in that, my lord, audio recording, the deceased earlier took a loan amount of rupees 11 lakh. And that amount was, my lord, along with the other petitioners, my lord, invested that amount for purchasing a land. But later on, my lord, that land was also not purchased, and that money was also not refunded to the deceased person, my lord.
To whom he gave that money?
To his wife, my lord. The present petitioner, my lord, item number 30.
I'm not aware.
Okay.
He is the wife of the deceased
It is
person.
also submitted by learned additional public prosecutor that it also reveals from the conversation between deceased Kulgen Burman and his younger brother Naveen Burman that the deceased took a personal loan of rupees 11 lakh. However, the wife of the deceased, along with the present petitioner, wife of the deceased took away the said money.
Otherwise, my lord, those audio clips, there is no note from the IO regarding that. Those are only alleged in the 164 statement of the witnesses. So, my lord, that may not be referred to be recorded, my lord. Because IO has not, there is no such note from the IO that after hearing.
I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. Considering the FSL report as well as postmortem report of the deceased person in this case, as well as from the materials available on record, it appears that at this stage, apart from mere suspicion, there is nothing on record which may implicate the present petitioner with regarding his involvement in the offense alleged in the FIR. Stop. In view of above, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of the investigation of this case. Stop. For the aforesaid reasons, the petitioner, namely Farid Ahmed, is hereby directed to appear before the investigating officer of Gitanagar PS case number 123/2024 within a period of 10 days from the date of this order and cooperate in investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Gitanagar PS case number 123/2024, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the condition of the, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. This anticipatory bail application is accordingly disposed.
Yeah, please, your lordship. I am for the, my lord, Mamoni Pathak, my lord, he is the wife, my lord.
Sharmila. This or same order,
Yes.
same order, with changes, name of wife will be there. Item number
38.
38. Exactly same order. Some changes will be there, I will make it. Hoise.
May it please your lordship.
Yes.
Lordship, case diary was called for along with the FSL report.
Is there?
No, my lord. IO has paid for some time, my lord. FSL report.
What is the
my lord.
offense? 302.
FSL.
302, lordship.
We have to wait. We'll wait.
Lordship, my submission is that, lordship, this case is pending for want of CD, lordship, because, lordship, on 17/7/24, CD was there, but FSL report was not there. Then, lordship, 37/24 was fixed for CD.
How the applicant, how the deceased died?
Lordship, deceased died at the hospital, lordship. And
As a
deceased-
result of?
As a result, that the FIR is there, lordship. Lordship means kindly see the FIR.
No, whether there was allegation made against you, any allegation?
My name is not there, lordship. My name is not there because she happens to be the wife of my younger brother. And I have a separate household.
Okay, the wife
Wife of my
your
younger brother. Yes, lordship.
What is the allegation?
Lordship,
She was subjected
to cruelty.
She was burned or what?
No, that allegation is not there.
Assaulted.
Assaulted.
Case diary would be required. You have to wait.
Yes. Lordship, FIR was lost on 27/4/4.
Next week. Heard Mr. T. Kalita, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor, who prays for some more time for producing the case diary. Let the case diary, let this case be listed again on 16 August for case diary.
Much.
Wait, case diary was called for.
Case diary received.
Page 9 is the affair. There is a collision of a vehicle and a motorcycle. The
accident,
rash and negligence, 304A is also there. One Jaul Ali, he was the driver. And on the receipt of information, police arrived at the place of occurrence, took both the drivers to the hospital. During treatment, driver of the motorcycle died. Now this driver of the Indica car, he fled away during the treatment. Now I am not the register owner, but just prior to 7 days prior to this incident, I purchased the vehicle by an agreement.
Signing a shell deed.
Yes, shell deed, I purchased the agreement.
But you were not the driver.
No, not driver. No.
Then how you are involved?
I am involved in a manner.
Your
I
vehicle
purchased a second-hand car. that was having some mechanical issue. I took to the
No, no,
garage.
no. Why you apprehend?
Oh, now I have been served with a notice and because I was asked to produce the driver.
Okay.
That is
Now, because it's a
Let him go.
conditional
cooperative,
appear.
cooperative investigation, my lord.
Heard Mr.
Jad Alam.
Mr.
Jad Alam.
Zaid Alam, learned counsel for the petitioner. Also heard Mr. B.V. Gogoi, learned additional public prosecutor. This application under section 482 of the BNSS, 2023 has been filed by the petitioner Azinur Ali Bepari, who is apprehending his arrest in connection with Gauripur PS case number 309/2023 under section 279/304A/427/379/411 of the IPC of the Indian Penal Code, read with section 13 within bracket 1 of the Cattle Preservation Act 2021. The gist of accusation in this case is that on 4/8/2023, one Dilbar Hussain had lodged an FIR before the officer in charge of Gauripur Police Station, inter alia, alleging that on 4/8, on that day, at about 10:05 p.m., an information was received at the police station regarding an accident which occurred between a four-wheeler vehicle and a motorcycle at supermarket near SBI ATM on the Gauripur Rupsi PW road. Accordingly, the informant rushed to the place of occurrence and came to know that the driver of the Indica vehicle bearing registration number AS01BE7785 drove the said vehicle in a rash and negligent manner, and after the accident, both the drivers of the Indica vehicle as well as motorcycle suffered from injury. However, both the injured were taken to Dhubri Medical College Hospital. However, the driver of the motorcycle bearing registration number AS17N6784 expired in the hospital. Learned counsel for the petitioner submits that he is no way involved in the offense alleged in the FIR, except to the extent that he happens to be the second-hand purchaser of the vehicle bearing registration number AS01BE7785. It is submitted by learned counsel for the petitioner that the said vehicle was purchased by the petitioner only 7 days prior to the accident. It is also submitted that when he fled away, driver,
That is
From this spot.
from the spot, no, he was
not
taken to
from the
hospital.
start, he was taken.
Taken to hospital. Thereafter.
You are not in contact with.
No,
He
because he
also-
was not my driver. I put the vehicle in a garage for some mechanical issue.
Okay. Learned counsel for the petitioner has also submitted that due to some mechanical defect which arose in the vehicle, he took the vehicle to a garage. However, he does not know how the vehicle was taken away from the garage and got involved in the accident in question. Stop. Learned counsel for the petitioner has also submitted that now he has received a notice from the
OC Gauripur, page 16.
officer in charge of Gauripur Police Station to appear, page number
16, Lordship.
under section 133 of the MV Act.
Last
And-
sentence, your Lordship will find, so you are directed to produce the driver of the at Gauripur.
wherein he has been directed to produce the driver of a vehicle involved in the accident. Stop. Learned counsel for the petitioner has also submitted that the driver is not in contact with the present petitioner. He was not employed by the present petitioner. Stop. Hence, he now apprehends that if he appears before the officer in charge of Gauripur Police Station, he may be apprehended. Learned counsel for the petitioner has also submitted that the petitioner is ready to cooperate in the investigation. On the other hand, London additional public prosecutor has produced the case diary of Gauripur PS case number 309/2023, which was called for in connection with this case. He has also submitted that you don't have any objection.
No.
He has also submitted that
Only his cooperation is.
if the petitioner cooperates with in the investigation, his custodial detention may not be necessary. Considering the submissions made by learned counsel for both the sides and as well as after perusing the materials on record, this anticipatory bail application is hereby disposed of with a direction that the petitioner shall appear before the investigating officer of Gauripur PS case number 309/2023 within a period of 10 days from the date of this order and shall cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with aforesaid case, he shall be allowed to go on bail of ₹30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. With this, with above observation, this bail application is hereby disposed of.
My pleasure. My lord, 482, my lord, under BNS, my lord. Case diary was called for. my lord.
Yes, very recent.
What is the offense?
Offense is, my lord, 409, 420, 465, 468, 471, 474, and 34. my lord. Here your lordship.
Forgery.
My lord, forgery is there. my lord. Your lordship will kindly come to page 13 is the FIR, my lord. I am not named in the FIR, my lord, in fact. Page 13, my lord. Here, my lord, allegation is that, my lord, some individual is making attempt, my lord, to obtain, my lord, permission for, my lord, birth certificate. That is, my lord, belated birth certificate, my lord.
Fake.
Which I am reading out, my lord.
Okay, no, not required.
Yes, my lord.
Fake birth certificate.
Fake, in fact, my lord, not fake birth certificate, my lord, to obtain
Documents
the permission.
documents necessary to take out birth certificate.
My lord, submission along with the application, my lord, some documents are to be required, my lord.
For obtaining delayed birth certificate.
Yes, my lord.
Okay, those certificates are fake.
Yes.
Yes.
And accompanying documents are
Yes,
fake.
yes.
Okay.
So this is the, my lord, as per this, my lord, allegation that some inquiry.
Your name is not there.
Not there.
Why are you apprehending?
I am apprehending because, my lord, I am a bona fide, my lord, applicant, my lord. I approached one Minul Hawk, my lord. One Minul Hawk, my lord. As per his, my lord, my
You
lord,
are applicant.
I am applicant, one of the applicant, my lord, for delayed birth certificate. I approached this person, Minul Hawk, my lord, and accordingly he applied for, my lord. And my lord, he applied for, my lord, through a, my lord, CSP, my lord. So that CSP owner was, my lord, arrested, my lord. On the, my lord, suspicion that, my lord, that CSP might be used for, my lord, uploading some fake documents, my lord. So in fact, my lord, some certificate or medical certificate or that is Form 10, it is said like this, my lord. Form 10 is, my lord, when there is no certificate at all, my lord, this is the certificate issued by the health center that he doesn't have any birth certificate. So this certificate, my lord, was, my lord, suspicion was there that this CSP was, my lord, involved in, my lord, uploading, my lord, documents, my lord, my lord, applications, my lord. So, my lord, but, my lord, he was released on bail, my lord, on the, my lord, basis that, my lord, the health, my lord, the register of the, my lord, that is, of birth and health, birth and
Moinul has been released.
released, my lord. That is on the, my lord, ground that, my lord, there is a certificate.
What is the,
That Moinul implicate this person, my lord. Moinul.
what Moinul said?
He says, my lord, মোৰ ক'ব লগা এই যে মই বহু দিনৰ পৰা ডিলেড বাৰ্থ চাৰ্টিফিকেট বনোৱাৰ বহু লোকৰ যাৱতীয় নথিপত্ৰ লৈ বাৰ্থ চাৰ্টিফিকেট উলিয়াই দিছো। আনাদাৰ উক্ত বাৰ্থ চাৰ্টিফিকেট উলিওৱাত দক্ষিণ চেনিমাৰীৰ মুস্তাফা আহমেদ son of so and so থানা লাহৰীঘাট তেওঁৰ পৰা মই ফেক স্কুল চাৰ্টিফিকেট so and so স্কুলৰ হেডমাষ্টাৰৰ চিল মোহৰ ব্যৱহাৰ কৰা স্কুল চাৰ্টিফিকেট মোক মুস্তাফা আহমেদৰ পৰা টকাৰ বিনিময়ত মই তাক টকা দিছিলো। তাৰ বিনিময়ত মই টকা দিছিলো। আমি দুয়ো এনে ফেক চাৰ্টিফিকেট দি আহিছো। আমি দুয়ো means Mustafa and my lord Moinul. My lord is present CSP owner, my lord. That is.
In fact, that is not correct. In fact, my lord, Mainul, when he was, my lord, found involved, my lord, he has taken my name, my lord. In fact, my lord, he has written as my name, my lord, as applicant in one or two, my lord, my lord, application, my lord. So that is my involvement.
From where he got bail, Moinul? From the trial court?
From the trial court, my lord. Mainul is also granted bail, my lord.
Arrested
After arrest.
Yes, my lord. And this.
Now, whether his arrest is necessary?
This
In
was
this
bona fide, my lord, applicant, my lord. He is,
present petitioner.
Present petitioner, yes, my lord. He is clearly implicated, and police note also shows that he is the main culprit, my lord, of this.
What
case.
police note?
Yes, this is forwarding, my lord.
The material is only of Moinul.
Mainul, man.
Mainul and the present petitioner both,
Who
my
is
lord.
one of the co-accused.
Yes. Here, police note says that the accused, namely Mustafa Ahmed, is the main person who leads the fake document of certificate, fake
No.
document and
on,
certificate.
On what basis police is saying?
My lord, the basis,
says
my lord,
statement of
that is the forwarding by the police, my lord.
No, no.
I cannot say, my lord, that police says, my lord, that is I did.
No.
What is there?
You have not understood my
My lord.
question. When police is stating something in forwarding report,
Some basis should be there.
There has to be some basis.
Yes, the basis
appears to be the co-accused, only co-accused statement.
Yes, Lordship.
Apart from his statement.
That is, my lord, now investigation is going on, my lord. Investigation not complete.
And one Nurul, he is also granted bail, my lord, because there is a, my lord, letter from the authority that these are not fake, my lord. By the, my lord, register of birth and death, Lahorigat PH.
Okay, heard Mr. J.C. Bora, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioner Mohammad Mustafa Ahmed, who is apprehending his arrest in connection with Lahori Ghat case number 121 slash 2024 under section 409 slash 420 slash 465 slash 468 slash 471 slash 474 slash 34 of the Indian Penal Code. The gist of acquisition in this case is that on 6/6/2024, one Pramod Sharma, ACS, had lodged an FIR before the Superintendent of Police, Moregaon District, inter alia, alleging that it was brought to the notice of the first informant that some of the individuals of the Moregaon districts are submitting fake and forged certificate while praying for obtaining permission for delayed birth certificate. It is alleged in the FIR that while applying for delayed birth certificates, some documents like non-availability certificate within bracket Form 10 and medical certificate are forged and submitted along with the application. Stop. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. However, he has submitted that he himself had applied for obtaining delayed birth certificate through one person, namely Moinul Haq, who is a co-accused in this case and who has already been granted bail by the which court?
By lower court below.
By the trial court.
Yes.
Stop. Learned counsel for the petitioner has submitted that the said Moinul Haq might have used his name while applying for delayed birth certificate in more than one instances. Stop. Learned counsel for the petitioner has submitted that the petitioner, where do you stay? What do you do?
My lord, I am just, my lord, I am a teacher in the, my lord, masjid, my lord.
Teacher in masjid?
Masjid, my lord. That is like, my lord.
Teacher has to be in some
Mawlavi, yes.
madrasa.
Madrasa, it's not madrasa in the masjid, my lord. There are some learning, Arabic learning, my lord, classes are there, my lord.
It may not be teacher, it may.
Title line.
He's called Molobi, my lord.
He's presently okay, that is not required. He is a Maulavi at a masjid where?
That is Muktab teacher, my lord. As I
Muktab.
As I am told, my lord. Muktab teacher.
No, but he may not be knowing your
Yes,
case.
my lord.
He is a Maulavi in a masjid in
that place, my lord.
in Moregaon district. Stop. And he is ready to cooperate in investigation if he is allowed to go on bail. On the other hand, learned additional public prosecutor produced the case diary of case diary of Lahori Ghat PS case number 121/2024 and has vehemently opposed the grant of bail to the petitioner on the ground that co-accused Moinul Haq has implicated the present petitioner as being involved in obtaining fake certificates. Stop. I have submitted. How many accused are there? In the FIR, nobody has been
Nobody's name, my lord.
So how many have been arrested?
We need two arrested.
One Nurul is, my lord, also released, my lord.
Nurul statement is here, my lord, co-accused. And
Where is the case diary?
Mainul
And have
statement is here.
considered the submissions made by the counsel. On perusal of the case diary, it appears that apart from accused Moinul Haq, one Nurul who was arrested in connection with this case has already been released on bail. Stop. And the only implicated materials against the present petitioner is the statement of co-accused Moinul Haq, which was recorded by the investigating officer during investigation. Stop. Considering the nature of this case and the facts and circumstances as revealed from the case diary, this court is of considered opinion that if the above named petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of the investigation of Lahori Ghat PS case number 121/2024. Stop. Hence, the petitioner and the above named petitioner is hereby directed to appear before the investigating officer of Lahori Ghat PS case number 121/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with above mentioned case, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. With above observation, this anticipatory bail application is hereby disposed of.
Deeply obliged.
Then 44.
Yeah, diary not received.
May I please your lordship. My lord, here in this case, very unfortunate, my lord. Only 12 years girls, my lord. She has committed suicide, my lord. My lord, now the father has resigned the case in a murder case. Mother already in custody, my lord. My lord, present petitioner, my lord. Petitioner's granddaughter's daughter died. Granddaughter's daughters died. My lord, he's a great grandmother maternal side.
Granddaughter's daughter?
Granddaughter's daughter died. Now her house.
Who is the petitioner? Is the grandmother?
No, my lord.
Great grandmother. Grandmother's mother.
Grandmother's mother. My lord, her house, my lord, situated 4 kilometer distance, my lord. Now she is a government employee, my lord. I have at the relevant time, my lord, he was in.
How in 41 years of age you became great grandmother?
No, my lord. Present petitioner's granddaughter's daughter died.
What is you are great
grandmother.
But you are only 41 years old.
No, my lord. Yes, my lord. My lord, very unfortunate, my lord. In fact, my lord, present petitioner, my lord, he is on duty. At that, my lord, I have annexed also, my lord, register, my lord, attendance register. At that moment, the incident took
What
place.
is the allegation against you?
My lord, only allegation, my lord. Your lordship, one line I am reading, my lord. One line, your lordship will understood, my lord. Page 9, my lord, middle portion.
14, page 14.
Page 14, my lord. যোৱা 16/7/2024 ইংৰাজী তাৰিখে মোৰ স্ত্ৰীয়ে ইনফৰমেণ্টছ ৱাইফ মাকৰ ঘৰৰ পৰা গুৱাহাটীলৈ ওলোৱাত কাৰণ she is my lord working in Guwahati for his work purpose
He came to her mother's house. When he came back to Guwahati, deceased wanted to go with that mother. At that moment, he prevented, no, you should not go to the Guwahati, you stay here, you study here. This is the reason, my lord. Mor ছোৱালীৰ জনীৰ লগত যাব বিচৰাত মোৰ স্ত্ৰী আৰু 2 নম্বৰ 3 নম্বৰ
Who is the wife of the first informant?
wife, my lord, Manjuara Begum. He is in my lord in custody, my lord. He is a mother, my lord.
And your name is?
My name
Number
is my
three,
lord,
number three.
3, Basiron.
Basiron.
He is a government employee, my lord.
How Manjuara is related to you? Manjuara is your
Manjuara, my lord, my
granddaughter.
Granddaughter's daughters died. I am, my lord, 4 kilometer distant. I am residing at that relevant point of it at 10 p.m. My lord, I was in hospital duty, my lord. My lord, this is the situation, my lord. Now police after me on the basis of this, purely, my lord, on suspicion. Nothing, my lord. My humble
Now,
submission.
were you present on 16/7/20?
Your lordship, kindly see page, my lord, attendance register I have annexed, page 16, my lord.
On 16/7, were you present?
Yes, my lord. My lord, this is the type copy, my lord, Barnacle, my lord, original attendance register, page 17, my lord.
Page number?
17, my lord. My lord, this is the fact, my lord.
When she died?
My lord, on the
allegation is she was
hanging, my lord.
tortured.
Allegation, my lord, torture. My
That
lord, on-
when
my
the
lord.
mother refused to take her
Yes, my lord.
along with her to Guwahati.
Guwahati, my lord. You should not go to the Guwahati. You read here. What happened, my lord? The deceased.
Then how she committed suicide?
My lord, committed suicide when mother.
How? By hanging?
By hanging, my lord. By hanging. My lord, my humble submission, my lord. My lord.
No, allegation is that, my lord, জানিব পৰা মতে মোৰ ছোৱালীক পৰিকল্পিতভাৱে হত্যা কৰি 4 নং আসামীৰ পৰামৰ্শ মতে 4 নং is somebody else, my lord.
Somebody else, my lord.
বাকী আসামীগণে ঘটনাটোক চিপ লৈ আত্মহত্যা ৰূপ দিবলৈ চেষ্টা কৰে তথা স্থানীয় গাঁওবুঢ়া আৰু প্ৰশাসনক কোনো ধৰণৰ খবৰ নিদিয়াকৈ গোপনে মৃতদেহটো সৎকাৰ কৰিবলৈ জোৰ-জা চলায়. That is, it was found hanging. But it is a
No, you may have a case, good case, but case diary would be
is
required.
required.
My lord, my only yes, my lord. I am, my lord, I agree with your lordship, my lord. My lord, my humble submission. Since I am a lady, my lord, I am a government servant. My lord, interim, my lord, consider, my lord. If, my lord, any against comes, if the arrested acquit say against me, my lord, straightway my bail would be rejected, my lord.
Heard Mr. A. Mannaf, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that the case diary which was called for has not yet arrived. Stop. And prays for some more time for producing the case diary. On the other hand, learned counsel for the petitioner submits that the petitioner is a government servant, and on perusal of the documents annexed along with the application, it would reveal that the deceased, who is the great granddaughter of the present petitioner, died when her mother refused to take her along with her to Guwahati on 16/7/2024. Stop. It is submitted by learned counsel for the petitioner that on that day the petitioner was where you were
My lord,
on that day.
my lord, I am in hospital duty, my lord.
What do you do in hospital?
My lord, I am the 4th gate employee, my lord. My
She
lord,
was in the hospital. Which hospital?
my lord, hospital's names, my lord. My lord, my lord, Mahanta Mahatma Gandhi Model Hospital, Adabari, Nalbari, page 3, para number 4, my lord. Mahatma Gandhi Model Hospital,
Adabari, Nalbari.
my lord, I have annexed also, my lord, identity card also.
And to support his submission, he has annexed the identity card as well as the attendance sheet of the said hospital, which shows that on 16th, the petitioner Basiron Nessa, who is a grade 4 employee of the said hospital, was present in the said hospital. Stop. In view of above, till the arrival of the case diary. Stop now. Let this, when you will bring the case diary?
19.
No, I am giving interim.
Then, my lord, September, sometime, my lord.
Not
5th September, 5th September.
On 5th September may be very long. Bring it on 22.
Yes.
On 22nd of August 2024. However, considering the facts, considering the submissions of learned counsel for the petitioner narrated, discussed herein before, the petitioner is directed to appear before the investigating officer of Mukalmua Police PS case number 207/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If she does so within the stipulated period of time, in the event of her arrest in connection with Mukalmua PS case number 207/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this matter be listed again on 22nd August 2024.
With postmortem report, my lord. Obliged, highly obliged.
Item number 27.
Orders Matiduk. Admission, will it be merely admission?
My lord, notice maybe it should, it's a POXO related involved, my lord.
So, record.
They were only
2023 has been filed by the appellant impugning the judgment dated 11/7/2024 passed by learned Sessions Judge Kokrajhar in Sessions case number T2/47/2022, whereby the appellant was convicted under section 376(1) of the Indian Penal Code.
Is behind the bar since 13/12/2022. That is the date of the judgment. And due to which this delay occurred, Your Lordship, there is no one to give him the proper advice and the documents. And such delay of 521 days is occurred.
Where have you explained the delay?
Lordship, paragraph
What is the punishment? 302, life imprisonment.
part 2, 7 years has been
7 years.
sentenced, 7 years. Lordship, there are two accused persons. One is acquitted and this person was sentenced for 7 years, Lordship. And the whole judgment is based on one witness, PW3, Lordship.
What was the incident?
Incident was, the allegation is that this applicant beaten up this deceased person behind with a bamboo lathi.
Okay.
And there is no eyewitness as per the applicant, but for the prosecution, PW3 was the eyewitness, but in the evidence, it appears that she was not the eyewitness. And the Honorable Court considered one part of the PW3 and convicted this person, and one person has been acquitted. So that is the,
Now, where have you mentioned the reasons for delay in your application?
page 4 of the
Para?
para 9.
Yes, Mr. Sharma.
This notice may go to check this one or two, whether they have any objection or not.
No, this is a POXO case.
Yes.
No.
Pokso. No lordship.
Pokso, lordship.
302.
Here statement defend, whatever you say, we will do it.
Lordship, delay is there. So otherwise, Lordship, 7 years, Lordship, we normally do not file objection.
Okay, then I am condoning those because you are not legal aid counsel. You are,
Yes, lordship, I'm legal aid
you are
counsel.
legal aid
Yes.
counsel. That submission you have to make.
Lordship, it was mentioned in the cause list. That's why I have not.
Okay.
It was specifically mentioned.
Heard Miss
And Chaudhary.
N.
And Chaudhary.
N. Chaudhary, learned legal aid counsel. Also heard Mr. B. Sharma, learned additional public prosecutor. This interlocutory application under Section 5 of the Limitation Act, 1963, has been filed by the applicant for condoning the delay of 521 days for preferring the connected appeal, whereby the applicant has impugned the judgment and order dated 13/12/2022 passed by learned Sessions Judge Dorong Mongoldoy in Sessions case number 77 within bracket DM/2018 under section 341/302/34. No, in the section ito na lagi.
Conviction.
Whereby the present applicant was convicted under section 304 part 2 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 5,000 in default of payment of fine, to undergo further imprisonment for 6 months. Learned legal aid counsel for the applicant has submitted that the applicant is unable to engage a counsel of his own, engage a counsel, and therefore he was provided with the services of legal aid by the Assam Legal Services Authority. And legal aid counsel has further submitted that there is a good of appeal and there is every possibility of appeal being decided in the favor of the present applicant. So she has also submitted that she has mentioned the reasons for delay in preferring the connected appeal in her application. Stop. I have considered the submission made by learned counsel for both the parties, learned counsel for the applicant as well as learned additional public prosecutor. Considering the grounds mentioned by the petitioner applicant in paragraph number 9 of his delay condonation application, this court is of considered opinion that the applicant has sufficiently explained the cause for causing delay of 521 days in filing the connected appeal. Stop. In For the aforesaid reasons, the delay of 521 days in preferring the connected appeal by the applicant is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected appeal and list it for admission after a period of 1 week.
Lordship, in the prayer, I have mentioned the appeal along with the analogous application. There is another.
No, if appeal is allowed, analogous application you may file it.
Okay.
50.
May I please, your lordship? Lordship, in this case, lordship may call for the LCR, your lordship.
Okay.
In this matter, LCR was not called for, and this is a POXO case, your lordship.
Appeal has been admitted.
No, your lordship. This came up before.
Because I don't know whether it is typographical or intentional.
My lord, it is reflected here. Only, my lord, police PS now PS name is, my lord, wrongly written, my lord. Kindly see page number 8, my lord. Last paragraph, my lord. Uluwani PS case number so and so and Uluwani PS case number so and so, my lord. Here rightly written, my lord. Here. My lord, next page, my lord. Next page, my lord. Subpara, my lord. Age and interior, my lord, measure. Next paragraph, my lord. Bhuragaon PS, my lord. This is wrong, my lord. Only, my lord. Instead of Bhuragaon PS, my lord. This is my Uluwani PS, my lord. Only that word, my lord.
Heard Mr.
HP Gwala, my lord.
H.P. Gwala, learned counsel for the applicant. This interlocutory application has been filed by the petitioner in connection with AB case number 2042/2024, praying for correction of a typographical error which has crept in the order dated 5/8/2024. Stop. Learned counsel for the applicant has submitted that by order dated 5/8/2024, the applicant was allowed to go on interim anticipatory bail along with some other co-petitioners. Now, all are applicants here.
All are applicants.
Applicants were allowed to go on interim anticipatory bail by the court. However, in the page number 3 of the said order, the police station case has been referred wrongly as Bhuragaon PS case number 85/2024 instead of what should be the correct?
Uluwani PS case number
Uloni PS case number
85/2024.
85/2024. On perusal of the record, it appears that the aforesaid error is a typographical error which needs to be corrected. Stop. In view of above, this interlocutory application is allowed, and in the order dated 5/8/2024, passed in AB number 2042/2024, the police station case appearing in the last but 2 paragraph as Bhuragaon PS, as within inverted comma, Bhuragaon PS case number 85/2024, bracket, inverted comma close, shall be read as Uloni PS case number 2024. There are two police stations case. Uloni 84 and 85.
Rose case, my lord.
So which will come 85?
85.
Okay. This interlocutory application is accordingly disposed of.
Obliged, my lord.
What yet ki hearing?
This hearing matter.
We have no time.
My lord, this was listed and heard in many courts, my lord, number of times, but somehow it comes very in the last portion of the list. So, my lord, can it be fixed on 27th, my lord, as fixed item? 2021 matter, my lord, otherwise also quashing matter. It is more than 3 years now.
Heard Mr. R.P. Sharma, learned senior counsel assisted by Mr.
D. Dole.
D. Dole, learned counsel for the petitioner.
Yeah, no, informant, respondent.
Before that, learned counsel for the respondent. Before that, Agote Likebo heard Mr.
SK Deuri.
S.K. Deuri, learned counsel for the petitioner. This case could not be heard today due to paucity of time. Hence, on the request of learned counsel for both the sides, let this matter be listed again on 27th of August 2024
For hearing.
for hearing.
Well, there is an interim order.
The interim order shall continue till next week.
23 bonus.
May I please, Lord? I am appearing for a wife, actually, wife respondent. Think is that, Lordship, the maintenance amount is accumulating, Your Honor. They are not paying, taking advantage of the interim order passed by the Honorable High Court, Your Honor. That is the matter, actually.
What interim was passed?
That is 10,000 per month, Your Honor. That is also they are not paying before the Learned Family Court, Guwahati, Your Honor. I am in the face of starvation, Your Honor. I am unemployed, actually. That is the thing, Your Honor. They are depriving me from the maintenance amount.
Order for payment of maintenance.
Yes, order for maintenance.
Why are you not paying?
Lordship, as per my instruction, we are paying them, so I have no knowledge
Then
regarding this.
disputed facts.
Disputed. Think is that, Lordship.
My senior
Recently, I have
clerks-
filed an application with a learned trial court seeking direction to the other side to release the arrear amounts, Your Honor. Since last 2-3 months, they are not paying the amount, Your Honor.
No, but
That's why I have mentioned this issue.
you pay, because today we may not be able to take it up because no time is left. Within 5 minutes, it will
A
not.
convenient date may be given, Your Honor, in presence of both sides, Your Honor.
When do you want?
At 27th of this month, Your Honor. 27.
Yes, Lordship.
Heard Miss
A. Lodha.
A. Lodha, learned counsel for the petitioner. Also heard Mr.
H.K. Sharma.
H.K. Sharma, learned counsel for the respondent. Due to paucity of time, this matter could not be heard today. Hence, let this matter be listed again on 27th of August 2024.
Impin order itself reflects when it was passed in the year 2022 that they are the chronic defaulter. Impin order reflects their second time revision, Your Honor. Second time they are filing revision.
No, you reserve some energy for 27.
Yes, yes.
Lordship, interim order is there, so it
It may be continued, Lord,
Interim
but
order
think
shall-
is that, Lord, they should respect the interim order.
Interim order shall continue. Finish.